ಲಿಸ್ಟು ಕಸ್ಟಡಿ ಅಲ್ವಾ? ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಲ್ಲ? ಇದೊಂದು 18ನೇ ಕೇಸ್ ಒಂದ್ಸಲ ನೋಡ್ಬೇಕಿತ್ತಮ್ಮ. ಪೇಪರ್ ಬುಕ್ 18 ಅಲ್ಲೇ ಇರುತ್ತೆ. 4 ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅಲ್ಲೇ ಬರ್ತೀನಿ. ಹೌದು, ಅಲ್ಲೇ ಬರ್ಬೇಕಾ? ಆಗ್ಲಿ ಜಡ್ಜ್ ಬರೋದಕ್ಕೆ ಟೈಮ್ ಇದೆ. ಕನ್ನಗಂಟೆ ನೋಡಿ ಬೋರ್ಡ್ ಸಿಗ್ತಾ ಇಲ್ವಾ?
ನಾನು ಮಾಡ್ತೀನಿ, 1 ನಿಮಿಷ ಕೊಡೋದಿದ್ದೀನಿ, ಮಾಡ್ತೀನಿ, ನಾನು ಕೊಟ್ಟಲ್ಲಿದ್ದೀನಿ, 1 ನಿಮಿಷ.
ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಒಂದ್ಸಲ ನೋಡ್ಬೇಕಿತ್ತಮ್ಮ. 18 ಅಲ್ಲ, ಅದೇ ಯಾವಾಗ ಪೇಪರ್ ಬುಕ್ ಮಾಡಿದ್ರು ಅಂತ ಬೇಕು.
ಸ್ಕ್ರೂಟಿನಿ.
ಇದೆಯಮ್ಮ ಪೇಪರ್ ಬುಕ್? ನೋಡ್ಬೇಕಿತ್ತು ಒಂದ್ಸಲ.
ಪರ್ದಲ್ಲಿ ಮೇಡಮ್ ತಗೊಳಲ್ವಾ ಮೇಡಮ್?
ಅಲ್ಲೇ ಇದೆಯಮ್ಮ?
ಉಲ್ಟಾ ಇಟ್ಟಿದ್ದಾರೆ,
ಕೊಡ್ತೀನಿ.
ಅದೇ ಎಲ್ಲ ಫೈಲ್ಸ್ ಬಂದಿದ್ಯಾ? ಇದು ಬಂದಲ್ಲ. ಏನಿಲ್ಲ ಸರ್, ಹಾಗೆ ಕೊಡೋದು ಅಷ್ಟೇ. ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್, ಬಂದ್ಮೇಲೆ ಕೊಡಿ. ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ಮೆಂಟಾ? ಯಾವುದು ಇದೆಯಾ ಇವತ್ತು? ಮೆನ್ಷನ್ ಮಾಡಿ.
ಬ್ರಾಂಚಿಂದ ಗೀತ ಫೋನ್ ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ ಯಾಕೆ ಬರ್ತಿದ್ದಾರೆ ಅಂತ ಕರೀತೀವಿ. ಒಂದು ಕಾಟ
Serial number 13 ಅಲ್ಲಿ second successive petition. ಅಲ್ಲಿ ಶಿವಶಂಕರ ಮರಣ ಅವರ ಮುಂದೆ
13
serial number 13.
ಮೆನ್ಷನ್ ಮಾಡಿ. ಅದು ರೀಚ್ ಆದ?
13
ಆಯ್ತು, ರೀಚ್ ಆಗುತ್ತೆ.
ತಗೊಳ್ಳಿಮ್ಮ. ಥ್ಯಾಂಕ್ ಯು.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಓ,
ನಿಮ್ದು
ಲೆಟರ್ ಈ ಥರ ಎಲ್ಲ ಮಾಡಬೇಡಿ. ಯಾವುದು
ಫಸ್ಟ್ ಆಗಿ
ನನಗೆ ಈ ಥರನೇ ಆಗಿ ಒಂದು
ಏನು ಅಲ್ಲಿಂದ ಅದರಲ್ಲಿ ಇದರಲ್ಲೇ ಉಲ್ಟಾ ಮುಚ್ಕೊಂಡು
ಸರ್ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರಾ? ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರಾ ಸರ್?
ಅವ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ
ಹೋಗ್ಬೇಕಾ? ಅದೇ ನಾವು ಓಡಿ ಅಲ್ಲ ಅದಕ್ಕೆ ಅದೇ ನಾವು ಓಡಿ ಅಂತ ಆಗ್ತಾ ಇರೋದು. ಅಮೆಸರ್ಗೆ ಓಡಿ ಓಡಿ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಅದಕ್ಕೆ.
ಓಡಿ ಅಲ್ಲ ಚೆಂಬರಿನ
ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ನಮ್ಮ ಮೇಡಮ್ ಮೆಮೊ ಕೊಡ್ತಾರೆ. ಗೊತ್ತಾಯ್ತು. ಇವಾಗ ನಾನು ಹೋಗಿದ್ದೆ ಲೆಟರ್ ಮೇಡಮ್ ನನ್ನ ಮೇಲೆ ಕೊಡಿ ಮೆಂಬರ್ಸ್.
ಊಟ ತಿಂಡಿ ಎಲ್ಲ ಕೊಟ್ಟು ಹಾಸ್ಟೆಲ್ ಐಸ್ ಕ್ರೀಮ್
ಕೊಟ್ಟಿದ್ದೀವಿ. ನಿಮ್ಗೆ 2 ಮ್ಯಾಟ್ರ್ ಅಸೈನ್ ಆಗಿದೆ. ಆಲ್ರೆಡಿ ಮೆಸೇಜ್ ಹಾಕಿದ್ದೀವಿ ಅನ್ಸುತ್ತೆ ನಿಮ್ಗೆ ಯಾವ್ಯಾವುದು ಅಂತ. ಕೊಡ್ತಾರೆ ಸರ್, ಕರಿತೀನಿ. ಸೌಮ್ಯ ಸಂಪಂಗಿರಮ್ಮ ಹೆಸರಿಗೆ ಯಾವ್ದು 2 ಮ್ಯಾಟ್ರ್ ಅಸೈನ್ ಆಗಿರುತ್ತೆ ಕೊಡಪ್ಪ ನಂಬರ್. ಒಂದು ಪೇಪರ್ ಹೌದಾ? ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ಹೋಗಿನೇ ಆಗಿದೆ. ಇವಾಗ ನಾನು ನಿಮ್ಗೆ ಟಚ್ ಇದ್ರ ಮೇಲೆ ನೀವು ಇದಕ್ಕೆ ಸಿಸ್ಟಮ್ ಬೇರೆ ತಿರ್ಗಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಯಾರು ಹೇಳಿದ್ರು ತಿರ್ಗ್ಸಕ್ಕೆ?
ಅದಲ್ಲ ಅಗ್ರಿ
ಸಲ
ನೋಡಿ ಇದ್ರ ಮೇಲೆ ಮೌಸ್ ತಂದ್ರೆ ಅದೇ ಸ್ಟಾಪ್ ಶೇರಿಂಗ್ ಅಂತ ಕೇಳ್ತಾರೆ. ಸ್ಟಾಪ್.
ಓಕೆ ಡನ್. ಕಳಿಸಿ ನೀವು ತಗೊಂಡಿಲ್ಲ ಏನು ಚೇಂಬರಾ ಇಲ್ಲ ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಗೌರ್ಮೆಂಟ್ ಅವರು ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಅದೇ ಹೇಳೋದು ಮಿಸ್ ಆಗ್ಬಿಟ್ರೆ ಒಂದೊಂದು ದಿನ ನೋಡೋದಿಲ್ಲ. ಬಂದೇ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಇಲ್ಲ. ಲಾಸ್ಟಲ್ಲಿ ಆ್ಯಡ್ ಆಗಿದ್ದು ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್. ಇರುತ್ತೆ ಲಾಸ್ಟಲ್ಲಿ ಇದೆ ಅಂದರೆ ಇದೆ. ರವಿ ಸೀರಿಯಲ್ ನಂಬರ್ 43 ಇದೆಯಲ್ಲ ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಮೆನ್ಷನ್ ಮಾಡಿ. 43 ಇದೆಯಾ? ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಸ್ಟೇ ಏನಾದರೆ ಅದು ಫಾರ್ಮೆಟ್ ಇದೆ. ಚೇಂಬರ್ ಇದೆಲ್ಲ ಮೇಡಮ್ ಹೇಳ್ತಾರೆ. ಡೇಟ್ ಆಮೇಲೆ ಅದು ಪ್ರಿಂಟ್ ಕೊಡೋದು ಡೇಟು ರಜಾ ಸದ್ಯ ಇವತ್ತು ಬಂದಲ್ಲ 20th ರಜನಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಹಾಫ್ ಡೇ ಅಷ್ಟೇ. ಬಟ್ ಮೇಡಮ್ ಹತ್ರ ನಾನು ಏನೂ ಹೇಳಲ್ಲ ಹಾಫ್ ಇಲ್ಲ ಅಂತ. ಸುಮ್ಮನೆ ರಜಾ ಅಂತ ಹೇಳ್ತೀನಿ. ಎಲ್ಲೂ ಅಷ್ಟೇ ಬಂದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ ಅವ್ರು. ಹೀಗಾದರೆ ನಾನು ಬರ್ತೀನಿ. ಒಂದು ಮುಕ್ಕಾಲಷ್ಟು ಹುಷಾರಾಗಿದ್ದೀವಿ. ನೀವು ನನ್ನ ರಜಾ ಅಂದ್ಮೇಲೆ ಎಷ್ಟು ಲೇಟ್ ಭಯ ಇಲ್ಲ ನಿಮಗೆ? ಏನು ಮಾಡಿ ಸೌಮ್ಯ ಫ್ಲಾಪ್ ಹಾಕ್ಬೇಕು ಟೀಚರ್ಗೆ. ಸೌಮ್ಯ ಟೀಚರ್ಗೆ ಫ್ಲಾಪ್ ಹಾಕ್ಬೇಕು. ಅದೇ ಇದು ಜುಲೈದು ಕೊಡಪ್ಪ. ನೆಕ್ಸ್ಟ್ 11 ಕೊಟ್ಟಿದ್ದೀನಿ 10 ಇದೆ. ಜುಲೈ ಕೊಡಿ ಅಂತ ಮತ್ತೆ. ಲೇಟಾಗಿ ಬಂದೆ ಬರೋಕ್ಕೆ ಮುಂಚೆ ಬರಬೇಕು ಅಷ್ಟೇ. ನಾವೇನು ಗೊತ್ತಾ ನೋಡೋದ್ರೆ ಖುಷಿ ಇರ್ತಿದ್ದಾರೆ, ನಾವು ನೋಡೋದೇ ಇಲ್ಲ. ಆಮೇಲೆ ಯಾವಾಗ ಮೇಡಮ್ ಎಲ್ಲಿ ಅನ್ನೋದು ಗೊತ್ತಾಗುತ್ತೆ. ಇನ್ನೂ ಬಂದಿಲ್ಲ ಬಂದಿದೆ. ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ. ನಿಮ್ಗೆ ಏನೇ ಡೌಟ್ಸ್ ಇತ್ತು ಕ್ಲಿಯರ್ ಕೊಡ್ತೀವಿ. ರವಿ ಫೈಲ್ ಬಂತು. Any memos?
Lords, kindly, my lord. 482 petition, which was withdrawn before my lord at previous occasion.
File the memo.
Fresh matter. Last occasion also moved, well, but it's not, that's what.
Note. Yes.
Great.
1 minute, sir. I'll come.
Any adjournment? List 1, page 3, serial number 17. Page 4, serial number 18 to 21.
Serial number 20, my lords. Tomorrow, sir. Tomorrow.
Why not today?
The senior counsel has viral fever, my lords. Should be all right by today. Tomorrow we have.
Viral fever ಇದ್ರೆ tomorrow ಇಲ್ಲ ಆಗತ್ರಿ.
My lords, he is recovering, my lords.
20 ನಲ್ಲಿ ಏನಾಗಿದೆ? Counsel for the appellant prays for time, or prays for a day's time to address the arguments on merits. He undertakes to address the argument tomorrow without seeking further adjournment. Submission is placed on record list tomorrow. Yes.
Serial number 22.
Yes.
Counsel request this time not well.
Ganesh Kumar.
Ganesh Kumar.
ಏನದು ಬಂದಿದ ನಮ್ಮ ಮುಂದೆ. Counsel for the appellant prays for time. Appeal is of the year 2012. Counsel for the appellant undertakes to address the argument on merits on the next date of hearing. Submission is placed on record list. Finally, as a last chance. Finally, sir. Next date of hearing.
File
No
serial
date.
number 23 and 24.
Let serial number 23, my lord.
may I request my lord taken up next week, my lord, fixed date, my lord, for hearing, my lord, already.
Same.
Next week, 20.
All these matters finally as a last chance. No
Please, my lord.
further
Next week, my lord, I'll go on.
Yes. Next.
Page 6, serial number
Publish.
25 to 28.
Hmm.
Page 7, serial number 29 to 34.
31, my lord. Appellant was expired. I produced the certified copy.
Which one?
The 31 serial number.
31.
31.
When he died?
He died and last 4 months, my lord.
Yes, I will dispose this appeal.
I will produce the certificate of the certificate. 1 day date maybe.
Counsel for the appellant submits that the sole appellant reported to have died. He prays for time to produce the death certificate and to make his submission. List down.
Page 8.
My lord, serial number 32, my lords.
Hmm.
And for the appellant,
Hmm.
may I request my lords to have this matter in the next week, my lords?
This time, finally. Yes, next.
Serial number 33.
Obliged.
No
Your Lordship.
further adjournment.
Please, my lord.
Yes,
Serial number 33, Your Lordship. Kindly 2 weeks time maybe.
33. Adu hage, same. Finally, next.
Page 8, serial number 35. List 1, page 1.
Your Lordship, cause list 2, serial number 2, Your Lordship. 2 weeks time may be granted. I'm for the appellant, Your
Well,
Lordship.
JC matters.
No, Your Lordship, the appellants are outside, Your Lordship. They're
They're
not in judicial custody. They have been granted bail in the trial court itself, Your Lordship.
None of the appellants are in custody,
No,
right?
they're not in custody, Your Lordship.
Okay. Counsel for the appellant submits that none of the appellants are in judicial custody
2 weeks time may be
as
granted.
they are released on bail. Submission is placed on record. Office is directed to take note of the same. List for admission, final hearing.
Grateful,
One
Your Lordship.
submission, my lord. List 1, my lord. Serial number 40. Appellant is died, my lord. Last month, my lord. I will yet to be obtained the certificate copy of death certificate.
40.
40. Serial number
Other-
40.
Counsel for the appellant submitted that the appellant had died, has died. He prays for time to produce the death certificate. Yes, now. Immediately you have to get it and produce,
Serial number.
or really,
Yeah, immediate, homework, etc.
you have to get the death certificate immediately and produce it. Yes,
Serial number 43, offense under section 302, wrongly posted before this lordship, my lord.
okay. Division bench.
Division bench matter, my lord.
Counsel for the appellant submits that the appeal pertains to the appeal is to be decided by the division bench of this court. Hence, office is directed to take note of the same and take necessary orders. Yes.
Serial number 13 also, my lordship.
And
The
post
earlier
the matter before appropriate bench.
13.
Yes.
13, 1-3.
Hmm.
The earlier bail, successive bail petition disposed by the Honorable Shiv Shankar Amaranavar. The matter has to,
13.
please, my lordship.
ಏನಾಗಿದೆ ಅದು? ಹಾ. ಐ ಅಂದ್ರೆ ಸಸ್ಪೆನ್ಷನ್.
Yes, suspension of sentence.
Now the roster bench, this is the roster bench. ಯಾವುದು ಸರ್ಕ್ಯುಲರ್ ಇಲ್ಲ ಆ ರೀತಿ.
Next, kindly have it next week, my lordship.
ಯಾಕೆ ಈ ಬೆಂಚ್ ಬೇಡ ಅಂತನಾ?
ಆ ಥರ ಏನಿಲ್ಲ.
Then
ಮಂಡೇಗೆ ಹಾಕೋಬಹುದು, ಮಂಡೇಗೆ ಹಾಕೋಬಹುದು.
I will adjourn by another two months.
ಆ ಥರ ಏನಿಲ್ಲ. ಸೀನಿಯರ್ ಕೂರ್ಗ್ ಹೋಗಿದ್ದಾರೆ. ಅದ್ ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದು ನನ್ನ ಜಾಬ್, ನನ್ನ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ. ಅದಕ್ಕೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
Yes.
ಅದರ್ವೈಸ್ ಏನಿಲ್ಲ.
Today you are not ready.
ನಾ ಮಂಡೇ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ ಆಯ್ತು.
This time 13.
List 1, page 1.
Great.
Compliance of office objection for first time, serial number 1, Raja KP.
ಅದ್ರಲ್ಲಿ
1 week
finally
may
ಏನು
granted.
ಬೇಡ. Praise for time ಅಷ್ಟೇ.
1 week may granted to comply office
Praise
objection.
time. List of complaints of office objections.
2, Harish Badari.
Lordship, 2 weeks may,
Praise time. Praise 2 weeks time.
grateful, Lordship.
Next.
3, Balance Augustine.
For the appellant in this matter, Lordship. Praise for a week's time.
Praise 2 weeks time. Next.
4,
Much
Anusha.
obliged.
Another list of complaints. of
Anticipate 2
office
weeks time, my lords.
objections. Yes, praise time.
5, Vaidya Ravi.
Pray for appellant. 3 weeks of time.
Praise time. Next.
6, Gilraj Jude.
Absent no representation. List of the complaints of office objections.
7, Vaidya Ravi.
Pray for appellant.
8 also same.
Same.
Vaidya Ravi.
Praise time. List of complaints. Next.
Serial number 9.
Appear for the appellant, my lords. Appeal may be disposed as withdrawn, my lords.
Advertised for that time. Serial number 10. Kiran Kumar.
It is listed for the third time for complaints of office objections. Office has raised as many as 11 objections. The same are not complied with. I do not find any reason to adjourn the matter. However, to afford final opportunity list on. Next.
Serial number 11 for orders. Pratik KC.
I appear for appellant, my lords. ಇದರಲ್ಲಿ ಇವತ್ತು steps ತಗೊಂಡಿದ್ದೀವಿ, my lords. R2.
Counsel for the appellant submits that PF is paid for issuance of notice to respondent number 2. Office is directed to verify the same. If PF is paid, issue notice to respondent number 3. List after service of notice. Next.
Serial number 12. Santosh Nagrele.
Appear for the appellant, my lords. There is 136 days of delay, my lords. Kindly it may be controlled, my lords.
HGP to take notice for respondent. Number 1, 2 idara. Heard learned counsel for the appellant. On IA1, appellant and learned HGP on IA. Yes, 136 delay. I'll condone that. Suspension of sentence.
Lords, 2 weeks time may be given over hearing, my lords. We'll do the hearing over suspension of sentence, my lords.
For the reasons stated in so and so, IA1 of 2023 is allowed delay of 136 days in preferring the appeal is condoned. Next, learned counsel for the appellant prays for time to address arguments on IA2 of 2023. Issue notice to respondent number 2. List after service of notice. Next.
Obliged, my lords.
13 Arjun. 14 Raja KP. Mr. Deshpande.
And for the appellant in this case, madam, delay 182 days, accused is in judicial custody.
182 days. I'll condone the HCGP. HCGP to take
He-
notice for respondent number 1.
Madam, one submission is a special case NDPS as Madhukar S. Deshpande is representing the case.
NDPS.
NDPS Act, madam.
So HCGP beda. So he is already on record. Served.
Copy is already served, madam.
Yes. That's better. HCGP better. Heard learned counsel for the appellant on IA1 of 2024. Learned counsel for respondent is absent. No representation. There is delay of 182 days in preferring the appeal. For the reason stated in so and so, IA1 of 2024 is allowed. Delay of 182 days in preferring the appeal is condoned. Yes. 2. Suspension of sentence.
My lord, the appellant was hired as a
Madhukar Deshpande. ಏನಿದೆ? Whether he was on bail?
no, my lord. He was in judicial custody since from arrest. All
Counsel for absent ಅಂತ ಬೇಡ. Heard learned counsel for the appellant and learned counsel for the respondent on IA1 of 2024. ಅದೆಲ್ಲ ಹಾಕಿ IA allowed. Next. Learned counsel for respondent prays for time to file his objections to IA2 of 2024. List after.
date may be fixed, my lord.
Next. Or ಹಾಕಿ. Next. 2 weeks ಬಿಟ್ಟು ಕೊಡಿ. Next.
Serial number 15 Alima Amin.
P to take notice for respondent.
delay of
number
16
1.
days, my lord.
Third learned counsel for the appellant and the learned HCP on IA2 of 2025. There is delay of 16 days in preferring the appeal. For the reason stated in so and so, IA is allowed. Delay of 16 days in preferring the appeal is condoned. Yes, what about suspension?
Lord, the
offences for which the appellant is convicted are 372, 354, 304, section 5, 1 and 6, 11, 12 of POCSO. He is sentenced to undergo imprisonment, rigorous imprisonment for 20 years, my lord. And also a fine.
He was in custody during trial?
No, my lord, he was on bail and he has not misused the liberty granted to
On
him,
the
my
date
lord.
of conviction, he was taken to custody?
Yes, my lord,
Yes.
on the date. The complaint.
Learned HCGP prays for short accommodation to address his arguments on 1 of 2025. In the meantime, issue notice to respondent number 2 now. Respondent.
On
Yes.
date may be fixed, my lord, after 2 weeks, maybe on date.
On for trial court records. Note, post immediately after service of summons.
Obliged.
Further hearing, serial number 16. Viraj.
Okay, for the petitioner, my lords.
Yes, what do you say?
My learned friend had taken time.
Complaint, my lord.
What is your submission? You are contesting the petition?
Because the incident happened in Chintavandi.
I am not deciding that.
No,
I only brought it to your notice.
according to the complaint, I'm saying, it happened in both places. It
According to
happened
the
in Bangalore
medical,
also, in Chintavandi.
according to the wound certificate, it was in Bangalore.
It happened in Bangalore also. Earlier, on the same day, earlier
Yes.
it happened in
I-
Bangalore. After
yes,
that, it
what do you
happened in
say?
Chintavandi. It is clearly mentioned
Your lords,
in the
your
complaint,
lordship
my lord.
may reserve liberty to initiate malicious
And
prosecution.
dismiss as not pressed.
I am happy with that.
Yes.
Because the medical certificate, it is part of, the wound certificate is part of the charge sheet, which is,
You can make use of
Clearly mentioned in
please.
both places also, my
Then
lord.
counsel for the petitioner, after addressing the argument for some time, seeks permission to withdraw the petition as not pressed. However, with liberty to initiate proceedings for malicious prosecution in case he succeeds before the trial court. Submission is placed on record, petition is dismissed as not pressed. If the petitioner is advised to initiate proceedings for malicious prosecution, he can take necessary steps at appropriate stage.
Liberty reserved, your lords.
Yes. Next.
Serial number 17, Janani P. Prasanna Kumar.
Team. Yes. Huh?
Against the court used Millards, the court used had Millards preferred appeal. Appeal Millards disposed of Millards by common order. When Millards, the conviction was Millards upheld.
Appeal was disposed of.
Disposed of Millards by common order. Thereby Millards, the sentence was Millards modified by enhancing the fine amount.
Then why it is again for,
Only this particular appellant Millards wanted to contest.
there are batch of matters.
Correct, Millards. 4 Millards, same appellant Millards, 4 different transactions. Bank fraud. Millards was one of the manager Millards.
138.
No. CBI appeal Millards, bank fraud.
CBI.
CBI appeal. Bank fraud.
ಅವ್ರು ಯಾರು? ಅಲ್ಲರಿ ಅವ್ರು ಯಾರೋ ಬಂದು ನಿಂತು ಹೋದ್ರಲ್ಲ, ಅವ್ರು ಯಾರು ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ. Dismissed.
It was disposed of Millards by enhancing the fine amount and waiving of the sentence.
Who is he?
Party.
Subramanian.
He's a party.
In the case. Last 15 dates Millards.
ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ವಾ?
My advocate has returned from abroad and she is not well, madam.
Yaru?
Anita,
Yaru, who is she?
Janani, Madam Janani, madam.
It is
So I
posted
came, I am-
finally, sir. No further adjournment will be given.
Yes, so I'll tell,
I'll proceed.
no, I'll tell her, madam, because she just came from abroad and is not feeling well, madam.
That is your lookout, sir.
Please, I am applying, I have come for personally, madam.
Okay.
I pray for some time.
Agala, sir. Same accused, different accused.
Different account.
Different accused.
The manager in all that.
In all. He was representing in this connected matter also.
But in fact, really take Millards, the order date, Millards, past 15 orders Millards have been Millards with regard to adjournment of the rest of the appellant. Since Millards January has been,
Yes.
three counsels have changed. There has Millards been a detailed order that has been recorded by coordinate bench. Millards kindly take Millards order dated 22/1/25. 22/1/25. Detailed order Millards, Millards, the appellant is receiving
Order dated
22/1/25. One of the other Millards counsels who come on record. I think Millards immediately file their memo of retirement. The paper book maker.
Unfortunately, that is the order of the day now. Even the advocates are dancing to the tune of the parties. You are Mr. Subramanian?
Yes, madam.
ಆಯ್ತು.
May I request the court to kindly see observation in para 7 of the judgment agreement. Para 7, even Millards, in fact, given the liberty as on the date of disposal of the judgment, that is on 22nd of January. Para 7, the so and so, though not connected with the rights of the appellants in these appellants, who have submitted that he having represented appeal number 1, that is the appellant now, who is a public servant being manager of Indian Overseas Bank, Mahalla branch, should submitted that appellants conceding for the order of conviction would affect the rights of the accused number 1. This particular Millards then, as such, so and so is heard in the matter only to that extent. And Millards may kindly come to Millards para 12. It's paid. Court made this observation. Reserving the right for the accused number 1 to urge on merits of the matter, including the validity of the sanction order for the present purpose, in view of the categorical submission made by the learned counsel for the appellants that they would not intend to challenge the order of conviction. The conviction of present appellants needs to be maintained. It is made clear that because of the non-challenge of the conviction order of the appellants in these appellants, the rights of one of the accused so and so does not get affected by to be urged in his appeals. My lords, this was my lords made on 22nd January, my lords.
Yes.
Thereafter, my lords, 14 adjournments have been, my lords.
Similar allegations in this also?
Yes, sir. Identical.
Identical.
Identical allegations.
Yes.
All.
I'll pass similar orders.
Madam, I request to give some time because she will attend next time, madam. Because now she is not well after coming
No,
from
no,
abroad.
no, no. Your conduct speaks otherwise. Throughout.
Yes,
You
madam.
have also tendered unconditional apology before the coordinate bench. Counsel for the appellant is absent, no representation. Appeal memo kodi. The appellant is present. Appellant is present and pays for short accommodation to address the arguments on merits. The counsel for respondent opposes the move for an adjournment and submits that the conduct of the appellant is recorded in the order sheet dated 22/1/2025. Even though the matter is posted finally as a last chance, the appellant is not ready to address the arguments on merits. The counsel also brought to the notice of the court that in connected criminal appeal number 943 of 2011, along with connected matters, the appeals were disposed of by the coordinate bench of this court with a judgment dated 22nd January 2025. In spite of that, so and so, by confirming the order of conviction, however modifying the order of sentence, confirming the judgment of conviction, however modifying the order of sentence. This fact is admitted by the appellant. However, he seeks short accommodation. Even though there are no good grounds to adjourn the matter, I deem it appropriate to adjourn the matter by a few days to afford one more opportunity to the appellant to address the arguments on merits. Hence, this finally as a last chance. Here goes to 17th. 19th. No further adjournment will be given. Yes. If your counsel could not appear, you have to make your submission. Yes. The appeals ಅಂತ ಮಾಡಿ ಇದರಲ್ಲಿ batch of matters ಇದಾವೆ. Yes.
Serial number 18, R. Nagendra Nayak, P. Prasanna Kumar.
I am from appellant for 18 and 18.3, my lord. Give me a short accommodation. Paper book is not there today.
Paper book ಬೇಡ sir. Paper book ಇದೆ, ನೀವು ಅದನ್ನ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡು paper book not received, paper book not received.
I will argue tomorrow senior.
ಮನೆಗೆ ಬಂದು ಕೊಡೋಣ paper book.
I will argue tomorrow senior.
Yes, Mr. Bhagavan.
In one of the appeals, I appeared for the appellant.
Ready?
I just this morning I found out that paper books, when they are prepared, is not given. And as per the High Court rules.
Sir, I am not going by the rules, sir. If you want, I can give a finding. 2012 matter, paper book is ready. Trial court records are also ready. My request is to address the arguments on merits.
I will submit with your adjournment reasons. Karnataka High Court rules are framed and chapter 15, postings and adjournments of cases.
Yes.
Rule 4, 5 and 6 are important. Rule 4, on the first working day of every month, the registrar shall cause to be put on the notice board of the court a list of cases made ready for hearing during the immediately preceding month.
Yes.
Rule 5, cases selected out of the ready list for being posted for disposal in accordance with the rules hereafter contained shall be transferred to a list called warning list, and the said list shall be put up on the notice board.
Yes.
6, cases transferred from the warning list and posted for disposal shall be included in the daily list. Nothing is done.
Yes.
How do I know?
Whether you have collected the paper book,
No, not at all.
whether it is brought to your notice that the paper books
No,
are
it was
ready.
not brought to my notice.
ಕೊಡಿ ಇಲ್ಲಿ, ಇಲ್ಲ, previous order sheet ಕೊಡಿ. Learned counsel ಇದರಲ್ಲಿ ಬರೀವಿ ಯಾವ್ದ್ರಲ್ಲಿ 18 and 18.3 ನಲ್ಲಿ learned counsel for the appellant submits that he has collected the paper book and will address his arguments on the next date of hearing without fail. ಇದರಲ್ಲಿ 18.1 ನಲ್ಲಿ learned counsel for the appellant. Sir, I am dictating the order, sir.
Sorry.
Learned counsel for the appellant, referring to Rule 4, 5, 6 of Karnataka High Court, the rules of full Hakkodi, submits that no such procedure is followed by the registrar and therefore he is not ready. Next, the appeal is of the year 2012. The convicts have preferred this appeal. The paper book was ready long back and the matter is listed today for final hearing. At least today, learned counsel for the appellant came to know that the paper book is ready and the court is insisting him to address the arguments on merits since it is one of the oldest matters pending before this court for disposal. However, considering the fact that the matter was listed for the first time after 2015, I deem it appropriate to adjourn the matter by 2 weeks to enable the parties to get ready in the matter and to address the final arguments. Address arguments on merits of the case. List finally as a last chance. Next. Yes,
Serial number
it is
9.
posted finally. Yes. Next. Date kodtaro.
2 weeks.
But no further adjournment on any count.
Yes, ma'am.
Next.
Serial number 19, KV Narasimhan.
Lord, I appear for the appellant. It may be taken up next week, my lord, any date, the next week. We'll
Yeah,
address
okay.
our arguments. There's some inconvenience today.
ಕೊಡಿ ಇಲ್ಲಿ order sheet. Already coordinate bench ಮುಂದೆ parted ಆಗಿದೆ ಇದು.
Please, my lord, then
It was released.
released.
ಮತ್ತೆ
ಇನ್ನೊಂದು ಡೇಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡ್ತು.
ಇನ್ನೊಂದು ಡೇಟ್ ಮುಗಿಯೋತಿಗೆ ಮತ್ತೆ ರೋಸ್ಟರ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ. ಅಗೇನ್ ಹಿಯರಿಂಗ್ ಇನ್ ಪಾರ್ಟೆಡ್ ಅಂಡ್ ರಿಲೀಸಿಂಗ್ ಇಟ್.
Lords may take any date, my lord. we'll submit.
ಮಾಡ್ಕೊಂತ ಇದ್ದೀರಲ್ಲ ಸರ್. ಏನು ಆರ್ಗ್ಯೂಯಿಂಗ್ ಬಿಫೋರ್ ವೇರಿಯಸ್ ಬೆಂಚಸ್ ವಿಲ್ ಗಿವ್ ಯು ಪ್ಲೆಜರ್?
No,
Then
that's not the intention.
ಅರ್ಧ ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು, ರಿಲೀಸ್ ಮಾಡೋದು, ಎಟ್ ದ ಎಂಡ್ ಆಫ್ ದಿ ರೋಸ್ಟರ್ ಇಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡೋದು, ಬಿಗಿನಿಂಗ್ ತಗೊಂಡ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ, ಪಾರ್ಟೆಡ್ ಮಾಡೋದು. See, the coordinate bench has noted.
Please.
Counsel for the appellant prays for time. The appeal is of the year 2012.
It is noticed that the matter was heard in part before the coordinate bench and later got it released. Now again, the learned counsel for the appellant is seeking time. Since the matter is one of the oldest, since the appeal is one of the oldest matter pending before this court, I do not find any reason to adjourn the matter. However, to afford final opportunity, finally posted.
Please.
Next.
Great.
Serial number 20 adjourned, 21 Gujaran sir.
Good. So finally, the counsel for the appellant is absent, no representation. Order sheet dated 3/6/2025 reads as under. In spite of that, none appears for the appellant to address the argument. Arrow amicus modi. Amicus. She so and so is appointed as amicus curiae to assist the court and to address the arguments on merits. This is directed to furnish the memorandum of appeal and the paper book, vide, paper book, to the amicus curiae to enable him to address the arguments on merits. List finally as the last chance. For example, yes.
Serial number 22 and 23 adjourned, 24 K. Pasha.
Counsel for the appellant is absent, no representation. Appeal is of the year 2013. I do not find any reason to adjourn the matter, however, to offer final opportunity. Yes.
Serial number 25 A.H. Bhagwan.
Counsel for the appellant is absent, no representation. Order sheet dated 9/6/2025 reads as under. In spite of that, there is none appears for the appellant. Since the appellant and since the counsel on record for the appellant is not addressing the arguments, even after affording final opportunity, Shri so and so is appointed as amicus curiae. Yeah. So and so is appointed as amicus curiae. So this is directed to communicate this order and furnish appeal memo and paper book. Learned amicus curiae and learned HCP are directed to address their arguments on the next date appearing without fail. List finally as the last chance. Next.
Serial number 26 Burgess Therapy.
Counsel for the appellant is absent, no representation. On the last day, the order sheet dated 27/2/2025 discloses that appellant number 1 was present before the court pursuant to the bailable warrant, and the learned counsel on record submitted that he continued to represent appellant number 1. In spite of that, none appears today before this court. The appeal is of the year 2013. I do not find any reason to adjourn the matter, however, to offer final opportunity list. Finally, as a last chance. Next.
Serial number 27 Ganigar Vidi.
Counsel for the appellant is absent, no representation. Even on the last date of hearing, there was no representation. The appeal is of the year 2013. List finally as a last chance. Next.
Number 28, R. Kalyan, Inteshes Arbati. Connected matter Badantri.
Appear for appellant. Yes, 2 weeks time, madam.
For the respondent present.
Counsel for the appellant, place for time. The appeal is of the year 2013. Do not find any reason to adjourn the matter. Over to for final opportunity list one. It is posted finally. No further adjournment. Next.
Grateful.
Appealing for the appellants, my lord. Pray for short accommodation, my lord.
Today. The same place button. Appeal of the year 2013 list finally as a last chance. Finally posted. No further adjournment. Next.
Much obliged.
32, Giri Shankar.
Either same. Absent, no representation. Appeal of the year 2013. I do not find any reason to adjourn. Finally, na. Counsel for the appellant is absent, no representation. Order sheet dated 13/6/2025 reads as end. In spite of that, neither the appellant nor the counsel for the appellant are present to address the arguments or merits. Hence, so and so is appointed as Amicus curiae. You ready now? 1210.
30, serial number 30.
Finally post ಆಗಿದೆ already. Pass over. ಯಾವ್ದಿದು serial number?
Serial number 31, 32, 33, Arjun, 34, Krishnappa. Connected matter C.P. Puttraju, Swaroop.
Counsel for the appellant is absent, no representation. Order sheet dated 5/6/2025 reads as ended. In spite of that, there is no representation. So and so is appointed as Amicus curiae to represent the appellant and to address the arguments and merits. Office is directed to communicate this order to the learned Amicus curiae and to furnish copy of so and so. Learned Amicus curiae is directed to learned Amicus curiae and learned additional SPP are directed to address their arguments on the next date of hearing without fail. List finally as a last chance. ಯಾರು ನೋಡಿ ಅವರೇ 4-5 ಜನರಲ್ ಮಾಡಿ ಅವರೇ ಅಷ್ಟು ಜನರಲ್ ಮಾಡಿ. ಎಸ್. Next.
Serial number 35, Submit.
ಯಾರು ನಿನ್ನೆ ಇತ್ತ ಇದು ನಿನ್ನೆ ಲಾಸ್ಟಿಗೆ ಹೇಳಿದ್ರಲ್ಲ ಅದ ಪಾಸ್ ಓವರ್ ಇವತ್ತು ಬೇಗ ಮುಗೀತು ಅದಕ್ಕೆ.
35%. For admission, serial number 36, Rangaswamy MT.
Apply for appellant, ma'am. I am not feeling well, my lord. 2 weeks time may be granted.
Counsel for the appellant, please for time. Yes. Next.
Serial number 37, N. Sridhar, Muralidhar P.
Appealing for appellant. Appellant.
Yes.
ಕೊಡಿ order sheet ಕೊಡಿ.
Wife, daughter and brother-in-law of the deceased have released, my lord.
1 minute. One minute. Yes, according to the report, what is the opinion?
According to the surgeon and orthopedician, Kumar is to be produced
In court. He is
No.
fit.
Screws have been opened, my lord. Screws.
In cruise ಅಂದ್ರೆ.
What they've inserted for surgery, my lord, in the year 2023, my lord. The screws
ಆಯ್ತು
have,
ಅದನ್ನೆಲ್ಲ ನೋಡಿನೇ ಬರ್ದಿದ್ದಾರೆ ಅವರು ಡಾಕ್ಟರ್ಸ್ ಅವ್ರು ಸರ್ಜನ್ಸ್ ಲೇಮೆನ್ ಅಲ್ಲ ನಾನ್ ನೋಡಿ
it is spinal cord, my lord. It is not.
ಎಲ್ಲಿದೆ ಅದು?
No, report I have, my lord. Report I have. That is,
ಅದು ಇರುತ್ತೆ ಇಂಪ್ಲಾಂಟ್ ಇದ್ರೆ ಏನು ಆಗಲ್ಲ ಎಕ್ಸ್ಪೋಜರ್ ಆದ್ರೆ ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಬರುತ್ತೆ. ಎಲ್ಲಿದೆ ಅದು ಪೇಜ್ ನಂಬರ್? ಪೇಜಿನೇಷನ್ ನೀವು ಹಾಕ್ಬೇಕಲ್ವಾ ಅಟ್ ಲೀಸ್ಟ್. ಓದಿ.
my lord, it's spinal cord.
ಆಯ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿ.
There are no eyewitnesses, my lord. Based on the
Earlier
circumstances.
petition was dismissed.
No, my lord. This is the first time we have filed. First time.
This petition,
And
appellant is
wife, daughter and brother-in-law of the deceased have been
sole
released.
accused.
My lord?
Sole
No,
accused.
my lord. 4 accused and 4 child accused, my lord.
This appellant is
First accused, my lord.
A1.
Based on this one, my lord,
And how many accused?
4 accused and 4 other child accused, my lord. A3 is the wife, my lord.
Child accused ಅಂತ ಹೇಳಲ್ಲ ಲಾನಲ್ಲಿ.
CCL.
ಏನ್ ಹೇಳ್ತಾರೆ?
Child in conflict, my lord.
What about
A3 is the wife, my lord. A4 is the brother-in-law of the deceased. CCL4 is the daughter, my lord. E is the
A4 is
brother-in-law of the deceased, my lord. Wife, brother, my lord.
who is A2?
A2 is no, is not relative, my lord.
A1
He is the relative, my lord.
A1 is the friend of accused number 3.
A3 is the wife of the deceased, my lord.
A1.
A1 is the sister's son, my lord. Deceased. Sister's son, my lord. And the fiancé of CCL4, my lord. CCL4 is the daughter of the deceased, my lord. According to the prosecution, wife, daughter, brother-in-law have given the supari to A2 through A1, my lord. Even the money is also given by
daughter
and brother-in-law. When the money is also given by A3 and A4.
How much?
It was decided for 6 lakh, my lord, and it was given 50,000, 30,000 by wife, 20,000 by brother-in-law. There is no old enmity. It is in the prosecution, they have accepted, my lord.
Who is the fiancé of accused number 3?
My lord, A1 is the fiancé of CCL4, my lord. CCL4 is the daughter, my lord.
All all are in custody?
A3 released, my lord, A4 is released, and CCL4 is also released.
A3, A4 released?
Yes, my lord.
Ah,
Bail granted by this honorable court, my lord.
ಆಯ್ತು. What about A2?
A2 is in custody, my lord.
When accused number 1 was arrested?
11/2/2024, my lord.
Charge sheet is filed?
Yes, my lord. Even the trial is also, eyewitnesses have been already
How
cross-examined.
many witnesses are examined?
5, my lord. I
5.
produce the documents.
5.
5, my lord. R2 is also examined, my lord.
So prosecution side completed.
And except other witnesses are there, my lord. Only 5 has been examined, my lord.
How many witnesses are there as per charge sheet? How many charge sheet witnesses? Sixty-one.
Yes, my lord. 61, my lord. CW1 is examined, my lord.
Now what is, according to you, what is the medical complication?
My lord?
What is the medical complication? Why are you seeking bail on medical grounds?
He is suffering from pain, my lord. He is not able to sit, my lord.
Then?
There are no eyewitnesses, my lord,
ಬೇರೆ.
based on the
Only on medical grounds. ಅಂತ
medical
ಹೇಳಿದ್ರು.
ground, and there is he is not required for further prosecution because it's already charge sheet has been filed, my lord.
Now, as
Further
per
investigation is not required, my
For
lord.
the medical report, you are fit.
Kindly appreciate in the what trial court has highlighted in the page number, my lord. Accused number 1 is being given treatment in Victoria Hospital on the recommendation of doctor. He has suggested, my lord, in the rejected bail petition, my lord. But they are denying to give the treatment, my lord. Based on that, they are saying that they are saying to approach the old hospital where he has taken the treatment earlier.
ಆಯ್ತಲ್ಲ ಈಗ ಅದು. See, considering all the medical records and examination of the accused.
Suffering severe back pain, my lord, is not able to sit, my lord. Kindly appreciate that, my lord. And there are no circumstantial evidences, my lord. Based on only voluntary statement of the other co-accused, he has been arrested, my lord. Kindly appreciate, my lord.
Yesterday you said you are seeking bail only on medical grounds, not on any other grounds. Right? That was recorded in the order sheet.
I know, but it was not argued, my lord.
Yes. That was your candid submission.
And all, A3, A4 is also, they are also released, my lord.
Can you understand what I am saying?
I understood, man. Apology for that.
What is that? What do you
Medical ground.
Only on medical grounds. That was recorded yesterday. Yesterday means last date of hearing. Now you are raising so many grounds.
That was not argued, my lord, because it was directed to get the medical report.
You cannot do like that. Only for the purpose of getting the medical reports, you cannot say only on medical grounds I am seeking bail.
I apologize for that, my lord. Because it was not argued on merit, my lord. So it has.
You should understand. You know. You knew that.
I apologize for that. This honorable court has directed to get the medical report, my lord. So
Very strange. What are the grounds urged by?
There are no circumstantial evidences, my lord. Based on only voluntary statement of the co-accused, he has been arrested, my lord.
Is it not a circumstance?
In the complaint FIR, his name was not forthcoming, my lord.
Recovery of the incriminating materials on the basis of the voluntary statement, is it not a circumstantial evidence?
That is the trial matter.
Huh? Is it not a circumstantial evidence?
That is only in the trial it has to be decided.
Everything is to be decided in the trial, not in the bail application.
Yes, my lord, I agree.
I cannot decide a case now.
Yes.
It is the trial court which has to decide.
Kindly appreciate other, A3 and parity ground also A3.
Recovery of what? At the instance of the present appellant. What was recovered? What was recovered at the instance of the appellant?
Mobile has been recovered, my lord.
Then
Mobile screen lock.
what else? Yes, what do you say?
In the first attempt, his name was not there, my lord. It was in the
Yes. How the
January.
disease was done to death?
Yes. Severe hemorrhage due to the multiple injuries.
Madam, 1 minute. When you could not answer the questions, I asked the additional SPP. You should allow her to submit. Use of knife. How many knives and how many longs were recovered? Weapons were not recovered.
Yes, ma'am.
Not recovered.
It was shown the. I'm sorry.
Really?
Phone, mobile phone. It has been. That is the thing more highlighted, my lord.
Facts ibrigu gottilla. I have to decide this.
No, things recovered. It is not their phone. ಜೀವನ್ ಭರತರು ಉಪಯೋಗಿಸುವುದು ಅಪ್ಪೋ ಮೋನ್ಸ್ ಒಂದು ಸಿಮ್ ಇರುವ ಮೊಬೈಲ್ ಫೋನ್ ಉಪಯೋಗಿಸಿದ್ದಾರೆ 5G ಎಂದು ನಮೂದಿಸಿರುವ ಸಿಮ್ ಮೊಬೈಲ್ ಫೋನ್. ಧನುಷ್ ರವರು ಧರಿಸುತ್ತಿದ್ದ ರೆಡ್ಮಿ ಎಂದು ನಮೂದಿಸಿರುವ ಏರ್ಟೆಲ್ ಸಿಮ್ ಇರುವ ಫೋನ್. ಭರತ್ ರವರು ಬೆಣಿಸ ಚಪ್ಪಲಿ ವಿವರಣೆ ಅಮಾನತು ಕಜ್ಜಾಯ ಮೇಲೆ. This was the ಸ್ವಾಧೀನ ಪಡೆದುಕೊಳ್ಳ. This was the recovered material. 1, 2, 3 phones and 1 pair of chappal, my lord.
That's all. No weapons are seized. One minute. Charge sheet to column number 17 ಎಲ್ಲಿದೆ? Charge sheet ಎಲ್ಲಿದೆ?
Additional it has been given. Additional document, my lord.
Page number ಎಷ್ಟಮ್ಮ? Who is the appellant herein?
CCL 1 to CCL 3, my lord.
You come prepared. Counsel for the appellant and learned additional SPP submitted the report of the Chief Superintendent of Prison, Central Prison, Tumkuru, along with medical records and the opinion of the medical doctor. Counsel for the appellant, praise for time. Yes. You should come prepared with the facts of the case.
Serial number 38, DS Dalwa.
Preparing for the appellant, my lord. This is appeal under section 14 of the Atrocities Act.
Yes.
I'm seeking to enlarge me on bail. My lord, the offences alleged against the appellant is 302, 143, 147, 148, read with section 149 of IPC, 32V of Atrocities Act, and 312 of Karnataka Control of Organized Crime Act, my lord. My lord,
How many
in
accused?
total, there are 12 accused, my lord, and the appellant is the accused number 1. All other accused are enlarged on bail, similarly placed accused. And this is the first time the appellant is approaching this honorable court. The appellant was arrested on 3rd October 2018, my lord. Since 6 years, 8 months, he is in custody.
Whether you approached this court earlier?
No, my lord, this is the first time I am approaching before this honorable court.
Why?
My lord, because the similarly placed accused, that is accused number 2 and 3 bail petition were rejected by this court and the sessions court, my lord. Therefore, my chances were very dim. Therefore, I didn't approach, my lord. This is the first time I am approaching. Subsequently, after the enlargement of the similarly placed accused, my lord.
Similarly placed accused, who is that?
My lord, accused number, I am producing the memo, my lord.
Who are the similarly placed accused?
My lord, kindly see page number, the first, that is criminal petition, criminal appeal number 1875.
Sir,
That
I'm
is,
asking you, who is the accused who is similarly placed?
my lord, accused number 2, 3, 4, 8, 9, 10 and 11, my lord.
Similar allegations against them?
Yes, my lord. The allegation is that appellant along with this accused assaulted the deceased. And more importantly, my lord, the case of the prosecution is that
Yellide, charge sheet.
my lord, it's in page number 45, my lord, the column number 17 of the charge sheet. So, 44, my lord.
Yes.
ಪ್ರಕರಣದ ಆರೋಪಿ ವಿರುದ್ಧ ಸಂಕ್ಷಿಪ್ತ ಆರೋಪಣೆ. ಪ್ರಕರಣದ ಕೊಲೆಯಾಗಿರುವ ಮೃತ ರವಿಕುಮಾರ್ ಹೆಚ್ ರವರು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ನಾಯಕ ಜಾತಿಗೆ ಸೇರಿರುತ್ತಾರೆ. ಆರೋಪಿ 1, 2, 3, 5, 6, 8, 9 ರವರುಗಳು ಸವರ್ಣೀಯ ಜಾತಿಗೆ ಸೇರಿದ್ದು, ಕ್ರಮವಾಗಿ ಆರೋಪಿ 1 ಶೆಟ್ಟಿ ಬೆಲ್ಜಿಗ ಸೋನ್ಸೋ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿರುತ್ತಾರೆ. ಆರೋಪಿ 4 ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿದ ನಾಯಕ ಜಾತಿ ಮತ್ತು ಆರೋಪಿ 7 ಪರಿಶಿಷ್ಟ ಜಾತಿಯ ಆದಿ ಕರ್ನಾಟಕ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿರುತ್ತಾರೆ. ಆರೋಪಿ 1 ಮತ್ತು ಮೃತ ರವಿಕುಮಾರನು ಸ್ನೇಹಿತನಾಗಿದ್ದು, ಇಬ್ಬರು ರೌಡಿ ಆಸಾಮಿಗಳಾಗಿದ್ದು, ಒಬ್ಬರಿಗೊಬ್ಬರು ಕಷ್ಟ ಸುಖಗಳಲ್ಲಿ ಭಾಗಿಯಾಗುತ್ತಿದ್ದರು. ಮೃತ ರವಿಕುಮಾರನು 2013ನೇ ಸಾಲಿನಲ್ಲಿ ತುಮಕೂರು ನಗರಸಭೆ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 22ರಲ್ಲಿ ನಗರಸಭಾ ಸದಸ್ಯರಾಗಿ ಚುನಾವಣೆಯಲ್ಲಿ ಗೆಲ್ಲಲು ಆರೋಪಿ 1 ರವರು ಸಹಕರಿಸಿದ್ದಾಗಿ, ನಂತರ ದಿನಗಳಲ್ಲಿ ಮೃತನು ತನ್ನ ರೌಡಿಸಂನಿಂದಾಗಿ ರಾಜಕೀಯವಾಗಿ ಪ್ರಬಲನಾಗಿ ಬೆಳೆದು ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ 2016ನೇ ಸಾಲಿನಲ್ಲಿ ಉಪ ಮಹಾಪೌರರಾಗಿ, ನಂತರ 2017-18ರಲ್ಲಿ ಮಹಾಪೌರರಾಗಿದ್ದು, ಈ ರೀತಿ ಬೆಳೆಯುತ್ತಿದ್ದನ್ನು ಸಹಿಸದೆ ಆರೋಪಿ 1 ರವರು ಮೃತ ತನ್ನನ್ನು ದೂರವಿಟ್ಟಾಗ ಹಾಗೂ ಈತನ ಮೇಲೆ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣಗಳಲ್ಲಿ ಮೃತನು ಕೈವಾಡವಿದೆ ಎಂದು ತಿಳಿದು ಏನಾದರೂ ಮಾಡಿ ಒಂದು ಗತಿ ಕಾಣಿಸಬೇಕು, ತುಮಕೂರಿನಲ್ಲಿ ಇವನನ್ನು ಮುಗಿಸಿದರೆ ನಾನು ಡಾನ್ ಆಗಿ ಅವನಂತೆ ಹಫ್ತಾ ವಸೂಲಿ ಮಾಡಿ ಹಣ ಸಂಪಾದನೆ ಮಾಡಿ ಅವನ ಸ್ಥಾನಕ್ಕೆ ನಾನು ಬರಬಹುದೆಂಬ ಉದ್ದೇಶದಿಂದ ಪೂರ್ವ ಸಿದ್ಧತೆಗಾಗಿ ಲಾಂಗುಗಳನ್ನು ಮಾಡಿಸಿ ಇಟ್ಟುಕೊಂಡಿದ್ದು ಆರೋಪಿ 2, 3, 4 ರವರುಗಳೊಂದಿಗೆ ಮಾತುಕತೆ ನಡೆಸಿ ಸಂಘಟಿಸಿಕೊಂಡು ಆರೋಪಿ 1 ರವರ ಸಂಘಟನಾ ನಾಯಕನಾಗಿ ಆರೋಪಿ 5 ಮತ್ತು 6 ರವರನ್ನು ಮೃತ ರವಿಕುಮಾರನು ಚಲನವಲನಗಳನ್ನು ಮಾಹಿತಿಯಂತೆ ತಿಳಿಸಲು ಸಂಘಟಿಸಿಕೊಂಡು ಆರೋಪಿ 4 ರವರ ಸ್ನೇಹಿತ ಆರೋಪಿ 8 ಮುಖಾಂತರ ಆರೋಪಿಗಳಾದ 9, 10 ಮತ್ತು 11 ರವರನ್ನು ತುಮಕೂರಿಗೆ ಕರೆಸಿಕೊಂಡು ಎಲ್ಲರನ್ನೂ ಸಂಘಟಿಸಿಕೊಂಡು ಸಂಚು ರೂಪಿಸಿ ಆರೋಪಿ 5 ಮತ್ತು 6 ರವರ ಕಡೆಯಿಂದ ರವಿಕುಮಾರನ ಚಲನವಲನದ ಬಗ್ಗೆ ಖಚಿತಪಡಿಸಿಕೊಂಡು ರವಿಕುಮಾರ್ನನ್ನು ಕೊಲೆ ಮಾಡಲು ದಿನಾಂಕ 22/9/2018 ರಂದು ಆರೋಪಿ 2 ರವರ ಮುಖಾಂತರ ಸೋನ್ಸೋ ಟೆಂಪೋ ಬಾಡಿಗೆ ತರಿಸಿಕೊಂಡಿದ್ದು ಟೆಂಪೋದಲ್ಲಿದ್ದ ಆರೋಪಿಗಳಾದ 1, 2, 3, 4, 8, 9, 10, 11 ರವರುಗಳನ್ನು ಕುಳಿತುಕೊಂಡು ಕಾಯುತ್ತಿರುವಾಗ ವಿಫಲವಾಗಿದ್ದು ನಂತರ ದಿನಾಂಕ 23/9/2018 ರಂದು ಬೆಳಿಗ್ಗೆ ಸೋನ್ಸೋನೆ ಟಾಟಾ ಸಫಾರಿ ಕಾರಿನಲ್ಲಿ ಸಂಚು ಹಾಕುತ್ತಿರುವಾಗ ಆ ದಿನವೂ ಸಹ ಪ್ಲಾನ್ ಮಿಸ್ ಆಗಿದ್ದರಿಂದ ಏನಾದರೂ ಮಾಡಿ ಮುಗಿಸಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಿ ದಿನಾಂಕ 27/9/2018 ರಂದು ಆರೋಪಿ 4 ರವರ ಮುಖಾಂತರ ಆರೋಪಿಗಳಾದ 8, 9, 10, 11 ರವರುಗಳನ್ನು ಕರೆಸಿಕೊಂಡು ದಿನಾಂಕ 29/9/2018 ರಂದು ಆರೋಪಿ 1, 3, 4, 8, 9, 10, 11 ರವರುಗಳು ಮಂಡ್ಯ ಜಿಲ್ಲೆ ನಾಗಮಂಗಲ ತಾಲೂಕು ಸೋನ್ಸೋ ಸೇರಿದ ಬೆಂಗಳೂರು ಮೈಸೂರು ರಸ್ತೆಯಲ್ಲಿರುವ ಡಿಜಿ ಲಾಡ್ಜ್ನಲ್ಲಿ ರವಿಕುಮಾರ್ನನ್ನು ಕೊಲೆ ಮಾಡಲು ಸಂಚು ನಡೆಸಿಕೊಂಡು ವಾಪಸ್ ಬೆಂಗಳೂರು ಬಂದು ಆರೋಪಿ 5 ಮತ್ತು 6 ರವರ ಕಡೆಯಿಂದ ರವಿಯ ಚಲನವಲನ ಬಗ್ಗೆ ಮಾಹಿತಿ ಪಡೆದುಕೊಂಡು ದಿನಾಂಕ 30/9/2018 ರಂದು ಸೋನ್ಸೋ ಟೆಂಪೋ ವಾಹನದಲ್ಲಿ ನಂದಿನಿ ಹಾಲಿನ ವಾಹನದಂತೆ ಬ್ಯಾನರ್ ಕಟ್ಟಿಕೊಂಡು ಆಯುಧಗಳಲ್ಲಿ ಟೆಂಪೋದಲ್ಲಿ ಇಟ್ಟುಕೊಂಡಿದ್ದ ಆರೋಪಿಗಳಾದ 1, 2, 3, 4, 8, 9, 10, 11 ರವರುಗಳು ಟೆಂಪೋ ವಾಹನದಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಆರೋಪಿ 5 ಮತ್ತು 6 ರವರು ರವಿಕುಮಾರ್ ಟೀ ಅಂಗಡಿ ಬಳಿ ಕುಳಿತುಕೊಂಡಿರುವುದಾಗಿ ನೀಡಿದ ಮಾಹಿತಿಯನ್ನು ಖಚಿತಪಡಿಸಿಕೊಂಡು ತುಮಕೂರು ನಗರದ ಕ್ಯಾತ್ಸಂದ್ರ ಪೊಲೀಸ್ ಠಾಣೆ ಸರಹದ್ದಿನ ಬಟವಾಡಿ NH-48 ರಸ್ತೆಯ ಬ್ರಿಡ್ಜ್ ಕೆಳಭಾಗದ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಟೀ ಅಂಗಡಿ ಮುಂಭಾಗ ಪ್ಲಾನ್ ನಂತೆ ಟೆಂಪೋ ಚಾಲಕನಾಗಿದ್ದ ಆರೋಪಿ 10 ರವರು ವಾಹನವನ್ನು ನಿಲ್ಲಿಸಿ ಬೆಳಿಗ್ಗೆ 8:15 ಗಂಟೆಗೆ ಸಮಯದಲ್ಲಿ ಟೀ ಅಂಗಡಿ ಬಳಿ ಹೋಗಿ ಸಿಗರೆಟ್ ತೆಗೆದುಕೊಳ್ಳುವ ನೆಪದಲ್ಲಿ ಬ್ಯಾಗ್ನಿಂದ ಖಾರದ ಪುಡಿ ತೆಗೆದು ರವಿಕುಮಾರ್ ರವರ ಮೇಲೆ ಎರಚಿದಾಗ ಟೆಂಪೋದಲ್ಲಿದ್ದ ಉಳಿದ ಆರೋಪಿಗಳಾದ 1, 2, 3, 4, 8, 9, 11 ರವರುಗಳನ್ನು ಟೆಂಪೋದಿಂದ ಇಳಿದು ಅಕ್ರಮವಾಗಿ ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಕೈಗಳಲ್ಲಿ ಲಾಂಗುಗಳನ್ನು ಹಿಡಿದುಕೊಂಡು ರವಿಕುಮಾರ್ ರವರು ಬಟವಾಡಿ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಓಡಲು ಹೋದಾಗ ಆರೋಪಿಗಳಾದ 1, 2, 3, 4, 8, 9, 11 ರವರುಗಳು ಲಾಂಗುಗಳಿಂದ ಮತ್ತು ಡ್ರ್ಯಾಗರ್ಗಳಿಂದ ಸಿಕ್ಕ ಕಡೆ ಹೊಡೆದು ಭೀಕರವಾಗಿ ಕೊಲೆ ಮಾಡಿ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ನಾಶಪಡಿಸುವ ಉದ್ದೇಶದಿಂದ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಟೆಂಪೋದಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಚಾಲಕನಾಗಿದ್ದ ಆರೋಪಿ 10 ರವರು ರವಿಕುಮಾರ್ನ ಶವದ ಮೇಲೆ ಟೆಂಪೋವನ್ನು ಹತ್ತಿಸಿಕೊಂಡು ಹೋಗಿ ಆರೋಪಿಗಳೆಲ್ಲರೂ ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಪೂರ್ವ ಸಿದ್ಧತೆ ಮಾಡಿಕೊಂಡಿದ್ದ ಸೋನ್ಸೋ ಇಟಿಯೋಸ್ ಕಾರಿನಲ್ಲಿ ಸಿರಾ ಕಡೆಗೆ ಹೊರಟು ಹೋಗಿದ್ದಾರೆ. ಆರೋಪಿ 1 ರವರು ಕರ್ನಾಟಕ ಸೇನೆ ಜಿಲ್ಲಾ ಅಧ್ಯಕ್ಷರೆಂದು ಬಿಂಬಿಸಿಕೊಂಡು ಆರೋಪಿ 7 ರವನ್ನು ಹೋಬಳಿ ಮಟ್ಟದ ಕರುನಾಡ ಸೇನೆ ಅಧ್ಯಕ್ಷನ ಬಿಂಬಿಸಿ 6, 7 ರವರ ಕಡೆಯಿಂದ ಕೃತ್ಯಕ್ಕೆ ಲಾಂಗು ಮತ್ತು ಡ್ರ್ಯಾಗರ್ಗಳನ್ನು ಮಾಡಿಸಿಕೊಂಡು ತಿಳಿಸಿದ್ದು ಆರೋಪಿ 1 ರವರು ಹೇಳಿದಂತೆ ಆರೋಪಿ 7 ರವರ ಆಯುಧಗಳನ್ನು ಮಾಡಿಸಿಕೊಟ್ಟ ಕೃತ್ಯಕ್ಕೆ ಸಹಕರಿಸಿರುತ್ತಾರೆ. ಆರೋಪಿ 18 ರವರು ಆರೋಪಿ 2 ರ ಸಂಬಂಧನಾಗಿದ್ದು ಆರೋಪಿ 1 ರವರು ಸ್ನೇಹಿತನಾಗಿದ್ದರಿಂದ ರವಿಕುಮಾರ್ ಕೊಲೆ ನಂತರ ದಿನಾಂಕ 1/10/2018 ರಂದು ಆರೋಪಿ 1 ರವರು ಕೊಲೆ ಪ್ರಕರಣದ ಆರೋಪಿ ಎಂದು ತಿಳಿದಿದ್ದರೂ ಸಹ ಆರೋಪಿ 1 ರವರನ್ನು ಮರೆಮಾಚಿಕೊಂಡು ಬೆಂಗಳೂರಿನ ಯಲಹಂಕದಲ್ಲಿನ ಬೈಕ್ ನಲ್ಲಿ ಹೋಗಿ ಬಿಟ್ಟು ಬಂದಿದ್ದು ಆರೋಪಿ 1 ರವರ ಬಗ್ಗೆ ಆಗಲಿ ಕೊಲೆ ಮಾಡಿದವರು ಯಾರು ಎಂಬುದಾಗಲಿ ಪೊಲೀಸ್ಗೆ ವರ್ತಮಾನ ತಿಳಿಸದೆ ಆರೋಪಿಗಳಿಗೆ ಸಹಕರಿಸಿರುತ್ತಾರೆ.
What was recovered at your instance?
My lord, in the charge sheet, it is alleged that longs and draggers were recovered, my lord, but in total, my lord, one humble submission. In total, there are 225 witnesses, my lord. As of now, only 19 witnesses are examined. And more importantly, my lord, FIR is registered against unknown person, my lord. Although there were eyewitnesses, this accused were unknown to the eyewitness, my lord. And based on their statement, my lord, this accused were implicated, my lord.
Based on whose statement?
Eyewitnesses statement.
Who are the eyewitnesses?
Eyewitnesses are PW 1 to 5. I have produced the deposition along with this petition, along with this appeal, my
And who else?
They are the prime witnesses, my lord. They have turned hostile in the court and they have not supported the case of the prosecution. And also they were in length, they were cross-examined by the learned public prosecutor and nothing is elicited, my lord. And this is also discussed in the other co-accused bail petition, my lord. On this ground, bail was granted to other co-accused who were similar allegations, they were facing the similar allegations, my lord.
Yes.
My lord, the eyewitnesses has clearly stated.
They have not supported on that.
Yes, my lord, I have.
Who are the PW 6 to 19?
PW 6 to 19, my lord, some of them are, they depose about the, one is 1 to 5 are the eyewitnesses, my lord, and
There are no other eyewitnesses?
no eyewitnesses, my lord. These are the prime witnesses. The others are some of the official witnesses. In the open court, they have not identified this accused, although they say that they were present at the spot and they witnessed the incident. They have not identified. They say the person who have assaulted is different.
Where are their depositions?
My lord, it's in page number 52, my lord. That is PW1. May I read, my?
Reading Beda. What was recovered at you, the instance of the appellant?
My lord, it is alleged that is long and dragger were recovered, my lord, but that is the witnesses have not supported, my lord. They say the police have brought and shown to them. It was not recovered at the instance of the appellant, my lord. My lord, while dispose of in the bail petition of the accused number 3 and 4, my lord, I have produced a memo. Kindly see page number 7, my lord. Para 9, my lord. Page 7, para 9.
Yes, what do you say?
Accused number
3, 4.
3, 4. All the accused are released except this one.
What has happened here, Lordship, is this one of the eyewitnesses was killed, Lordship, by conspiracy by accused number 1 and 3, because of the just before the trial started, because of which, Your Lordship, the rest of the eyewitnesses were not lost. That statement, that part of the statement that was there, even there in the judgment.
Judgment of?
Lordships, the order was
Releasing the other accused on bail.
My lord, may I make one submission, my lord? The accused number 3, say similar allegation was made against the accused number 3, my lord. That is also part of the record where they say that one of the eyewitnesses was killed. This was considered and bail was granted. And moreover, my lord, the judgment is passed in that case where all are acquitted, my lord. I am producing the copy of the judgment. Kindly see, my lord, in the same similar criminal appeal, my lord.
There is reference to the other case.
Yes, my lord, there is reference, my lord. Kindly see para 8, my lord. That just sorry, madam. Page number 6, first line, my lord, of the memo. She has further contended that one of the eyewitness, namely CW3, was murdered subsequent to filing of the charge sheet, and the appellant is an accused in the said case, my lord.
Page number ಎಷ್ಟು?
6, my lord.
First ಅದೇನು ಕಾಣಲ್ಲ.
ಅಲ್ಲ ಮೆಮೊದಲ್ಲಿ criminal appeal 1875 of 2020. 7, but page 6. Only I am reading the relevant. of the offense committed, he is entitled for bail.
More than 6 criminal cases prior to commission of the present offense, and after registration of the case, he is arraigned as an accused in the 3 more criminal cases. She contended that she has been identified by the eyewitnesses in the test identification and in view of the nature and gravity of the offense, not entitled for bail. That the one of the eyewitnesses, namely CW3, was murdered subsequent to filing of the charge sheet and appellant is an accused. Yes.
By considering all this, my lord,
What is the finding recorded by the coordinate bench?
my lord, kindly come to para 9, my lord, page 7. It is not in dispute that accused number 4 to 10 and 12 are on bail. As per the charge sheet allegation, accused number 1 to 4, 8, 9 and 11 assaulted the deceased with longs and dagger indiscriminately all over his body and committed his murder. Similarly placed accused number 4, 8 and 9 are on bail. Admittedly, petitioner was arrested on so and so. Hence, at the time of murder of CW3, he was in judicial custody. My lord, I am in a better position, my lord, because subsequently after granting of bail, that case, that is the murder of CW3, has ended up in acquittal, my lord.
In that case, you are accused number 1.
No, my lord, I am not. I am because, my lord, it is a politically motivated case. I am being implicated in one or the other cases. I am arraigned as accused number 7, my lord. This is the judgment, my lord.
Yes, what do you say? No, see,
I have produced
admittedly, the co-accused against whom similar allegations are made are already enlarged on bail. And according to you, CW3 was murdered subsequently. He is arraigned as accused number 7. And the accused are acquitted according to him. And even after taking note of the same, the coordinate bench has enlarged the accused number 3 on bail. Have you challenged that order? Then the criminals will take advantage of that. Till date, you have not challenged it, nor sought for cancellation of the bail of any of the accused. February 2025, we are in the month of June, still not challenged. That means it has reached finally. Yes. So you have not approached for cancellation of bail, nor challenge this order. And seek for cancellation. I will allow. The appellant, being accused number 1, in so and so, seeking for the offense punishable under section so and so, is seeking grant of bail. Or so and so, so and so. No, accused number 1, 2, 3, 4, 8, 9, 10, 11. Similar overtake. It is not as if only this accused had inflicted injuries. All other accused who are armed with similar weapons indiscriminately assaulted and caused the death. And accused number 10 was driving the tempo, has ran over the same on the dead body, on the deceased. And that was accused number 10 who thrown the chili powder. So overtact is there, but in spite of that, they were enlarged on bail. Why not this appellant?
Because the witness was killed, your lordships, the accused number 1 and 3 were reported in the murder of that.
But he was in judicial custody.
He was in judicial custody, your lordships, but that's not your lordships. When he was in custody, he used a phone to get in touch with the other.
Accused number 1 and 3. 3 is enlarged on bail.
And accused number 1, your lordships, he had destroyed the phone in the cell itself, your lordships. So the phone.
How can it be? How can it be? How can you call it as a cell? if he can do all those things.
The audited records your worship showed that the phone
But in spite of that, they are acquitted according to him. Maybe very, very serious allegations, I do admit. But they are acquitted. And the co-accused are already on bail.
just may take the matter on 20.
Yeah, okay, yeah.
They just, for my satisfaction, only on 20. So since COPA is no.
Okay, 1 minute. Third so and so, so and so. Learned counsel for the appellant submits that the appellant is arraigned as accused number 1. He was apprehended on 3/10/2018 and since then he is in judicial custody. Initially, FIR was came to be registered against unknown persons. Later, the accused were, in all, later, the accused were arrested and charge sheet came to be filed against accused numbers 1 to 12. As per column number 17 of the charge sheet, it was accused number 1, 1 to 4, 8, 8 to 11, armed with longs and dagger, indiscriminately assaulted the deceased, as a result of which he died. It was accused number 10 who was driving the tempo and thrown the chili powder in the eyes of the deceased before the co-accused assaulted him and before assaulting the deceased with lethal weapons. It is the allegation made against accused number 10 that he ran over the tempo on the injured. Next para. Learned counsel submitted that similar allegations are made against accused numbers, the other accused referred to above regarding the overtake. But in spite of that, all other accused except the present appellant are enlarged on bail. Next para. Learned counsel submitted that even though it is contended that CW3, who was one of the eyewitnesses to the incident, said to have been murdered by several accused, including the present appellant. Even though such a contention was raised before the coordinate bench while considering the bail application filed by the co-accused, a clear finding is recorded by the coordinate bench that accused number 1 was in judicial custody when CW3 was murdered. Moreover, the present appellant was arraigned as accused number 7 in the case of murder of CW3 is already acquitted by the trial court. Considering all these facts and circumstances, next, the counsel also submitted that PWs 1 to 5 were examined before the trial court, who are projected as eyewitnesses to the incident, but none of these witnesses have supported the case of the prosecution, and they have not identified the present appellant. Even according to the prosecution, the case is due to political rivalry. False implication of the present appellant cannot be ruled out at this stage. Even the deceased was a rowdy shooter. Considering all these facts and circumstances, the appellant is entitled to be enlarged on bail at Kintamurlo. PW5 is examined at that time. The prosecution has cited as many as how many witnesses? 225 witnesses. Out of them, only 19 are examined till date. Examination of other witnesses will take sufficiently longer period of time. Yes. Hence, a praise for allowing the appeal. For control on an additional SPP. Order sheet number ಕೊಡಿ. ಇದು ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಇಡೋದಷ್ಟೇ. Order sheet ಬರ್ಕೊಡಿ. Heard learned counsel for the appellant. Then an additional SPP placed for time. List on. When? Monday. Yes.
Serial number 39, Raghavendra K, MC Venkatarangaya.
ಯಾಕೆ? ಆಯ್ತು ತಗೊಳ್ಳಿ. Learned counsel for respondent number 2 had filed his statement of objections. Next.
Serial number 40, urgent 41, Amar Kori. Amar Kori.
Counsel. Hello, what is the petition for?
Petition was seeking for anticipate behavior of loss. Parallelly, the 482 petitions. The 482 petitions.
No, this is for anticipatory bail.
Yes. In the 482 petition, because there is an order passed. My case, the petitioner.
Yes.
Not to
Take advantage of that, not press this petition. No, nothing. Anyhow, there is an order. Then take advantage of that. Why you want to keep the appeal pending? File a memo. Learned counsel for the appellant submits that. Even though the appellant is seeking grant of anticipatory bail ಇದನ್ನು ನೋಡ್ಕೊಳ್ಳಿ. In a petition filed under section 482 of CRPC, the coordinate bench has passed the interim order directing the prosecution not to precipitate the matter. In view of the same, the appellant is not pressing the appeal for the present. Memo is placed, submission is placed on record. Counsel for the appellant undertakes to file a memo to that effect. In view of the above, appeal is dismissed as not pressed. Yes.
Serial number 42, Samuel S.
Notice agila. Yes, issue notice. And an additional SPP takes notice for respondent number 1. Issue notice to respondent number 2. Issue notice. Next. Okay. These two correct. ಯಾವುದು ಯಾವುದು ಏನಾಗಿದೆ? ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಆಯ್ತು, ಅದೆಲ್ಲ ಮುಗೀತು ಬಿಡಿ. Amicus curiae already appointed. What to do, sir? Today finally is the last chance. Nobody represented. There must be some representation when the matter is posted finally. Casually, last time also, ಎಲ್ಲ ಆಗೋಗಿದೆ. ಅಷ್ಟೇ ಫೈನಲ್ ಇಂತಾಗಿದೆ. At least ಅವ್ರಿಲ್ಲ ಅಂದ್ರು you should have made the submission. ಅಷ್ಟೇ ನೀವು ನಿಮ್ಮ ಜಾಬ್ ನಲ್ಲಿ ಬಿಸಿ ಇದ್ದೀರಿ. What the court should do? You expect the court to wait till 4:30? Then ಈಗ ಅದು ಅಮಿಕಸ್ ಆದ್ಮೇಲೆ ಈಗ ರೆಡಿ ಆಗಿದ್ರು. ತಗೊಳ್ಳಿ ಅದನ್ನ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ, ನಮ್ಮ ಇಲ್ಲೂ ಕೊಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್? ನೋಟ್ಸ್ ಇದೆಯಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್. Yes, proceed. Let's go. All the witnesses have supported? Yes. Supported. Yes. Hmm. Yes. Yes.
Accused number 6 was not the center of the trial.
Yes.
Charge was filed against other accused.
Yes.
A1 to
Yes. Sir.
A. And the charges offenses under section 144, 48,
Hmm.
323, 324, 307, 301, 349.
Charge was framed. Charge was framed for these offences. No.
Number 1, 8 and 9 were acquitted of all charges.
Yes.
Accused number 2 convicted of an offense under section 302.
Yes.
Sentence for the imprisonment for 5 years and paid fine 50,000 rupees. He was sentenced 1 year.
Hmm.
And he was acquitted of other charges. Accused numbers 3, 4, 5, and 7,
Hmm.
they were convicted for offense under section 324.
Hmm.
Sentenced to pay fine of 1,000 rupees. Before sentence, 6 months imprisonment.
No substantive sentence.
1 year sentence. 1 year and fine of
Yes.
1 year sentence. Fine of so for a section 149, so they were acquitted of all other charges, including 149.
Yes.
The appellant.
What are the grounds now?
Similar, I state the facts.
Now tell me the grounds on which you are preferring the appeal. What are the grounds?
Similar, prosecution case is similar. They're all related.
Hmm.
Accused number 1 to 5, 1 to 4, and 7. Further.
Charge ಏನಿದೆ? I am looking at the original document. Yes. What is that you are reading? Sir, bad a charge irudu whether these accused number 1 to 5, 7 to 9 having formed an unlawful assembly and being armed with deadly weapons like chopper, knives, clubs, stones caused rioting in prosecution of their common object, commit murder of Abbayappa and to cause hurt to the complainant and his family members and thereby committed the offence as alleged. That was not the charge? That was the charge extracted in the judgment. I am reading it. That is the charge. Now read the second charge. Whether the prosecution has further proved. Do you have the charge?
I have the charge. I'm reading. Charges at page 40. AC and the paper book, given by the office people were read.
Sir, do you have the judgment? Impugned judgment? Judgment in page number 10 ig bani.
Page 130. Page 10. Whether these accused number 1 to 5.
ಆಯ್ತು, ಅದು ಓದಾಯ್ತು. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಒನ್.
Whether the prosecution is further proof beyond doubt whether 25/8/2012 about 7 p.m. these accused persons being members of the Honorable Assembly having armed with deadly weapons and in pursuance of the prosecutions that come after caused rioting in front of the house in the country village and having assaulted Chinnamma, Venkatesh, Rajkumar and Sitama, caused her to them with an intention to cause their death and thereby committed an offense. Attempt to commit murder as alleged against them by the prosecution. That the prosecution has proved beyond doubt that accused number 1 to 5 and 7 to 9 prosecution of the Khan object were committing rioting, assaulted Chennamma, Venkatesh, Rajkumar, Sitama, and also alleged by voluntarily causing death to them by assaulting them with deadly weapons like blood, stones, chopper, knives, and thereby committed an offense as alleged. Whether the prosecution is further proved beyond doubt that accused number 1 to 5 and 7 to 9 assaulted him with club in his head, causing him fatal injury, which resulted in his death, and thereby the committed the murder of intentionally or knowingly causing his death, and thereby committed the murder of a fire.
Yes.
Similar, I will briefly state the facts. Accused number 1 to 5 and 7 are brothers.
Yes.
They are sons of one Maximum Naik. They are all residents of the village called Vidati in Malukka.
Accused number 1 to 5 and 7.
1 to 4
Hmm.
and 7.
Hmm.
They are sons of one Maximum Naik.
Hmm.
They are all residents of Vidati village.
Yes.
Accused number 5.
Hmm.
He has married granddaughter of Maximum Naik. That is niece of his father.
Yes.
The accused number 7 is the wife of accused number 8 is daughter of Maximum Naik. That is sister of the other accused. Accused number 9, the wife of accused number 9. They are all residents of Medahatti village. Similar, this is this one Apaya. He is resident of Upparalli village in Malukka.
Disease is not related to you.
Not related to
Yes.
He is Sambandhi of PW4.
Yes.
PW3 is his son. He is married.
What was the motive?
Other son. PW3, that is son of deceased,
Hmm.
has married daughter of PW4.
Daughter of?
PW4.
Hmm. Hmm.
On that day, deceased, his wife PW5, his son PW3, come to the house of the Sambandhi, that is PW4.
Hmm.
That the motive according to the prosecution is sum of rupees 100 or 150. According to one witness, it is 100 rupees. According to another, it is 150.
From?
PW. In that connection, there was this quarrel between accused number 1 and PW4 on the evening of 24/8/2012. This is a day prior to the date of incident.
21?
24/8/2012.
Yes.
This, according to the prosecution, is the motive of the offense. On 25th, at about 10:30 p.m., all these accused persons alleged to have come to the house of in the house of PW4 with the intention of committing the murder of PW4.
Yes.
It's in a van and approach. Armed weapons.
Yes.
And they started shouting near the house of PW4. By then, all in PW house were sleeping. Hearing the shout, the deceased is opened the door and said, "Come out of the house." He was assaulted by accused number 2. He fell down and screamed.
Assaulted with?
By
No, what was the weapon used? Club.
hearing the scream of deceased, the deceased, after he was shot, after he was assaulted, he falls down. Hearing and scream, hearing the scream, the other inmates in the house, that is PW1, with the companion and son of PW4, PW4, PW2, PW3, said they come out of the house. And so there was a quarrel. That they are also assaulted by accused numbers 3, 4, 5, and 7. So hearing this latter, PW5, PW6 and 7 were the neighbors. So they also come out of their house. And they try to pacify and they are also assaulted.
Yes.
PW2, who is the wife of PW4.
Yes.
PW3, who is the son of deceased. The PW6 and 7 were neighbors who intervened in this in the quarrel. So they were also assaulted in the suspense.
Yes.
And so thereafter, accused is arrested.
What is the relationship between the PW1 and PW2 and 3?
The PW1 is the son of PW4. PW2 is the wife of PW4. Mother of PW1.
So PW2 is the father of PW1.
PW2 is mother of PW1. PW4 is father of PW1.
Then PW3?
PW3 is son of deceased and son-in-law of PW4. He had married PW4's son.
Yes.
PW5 is the wife of deceased.
Yes.
Deceased, PW3 and PW5 had come to the house of that particular day. They had nothing to do with the accused.
Yes.
Accused did not know that.
Initially, the quarrel was between the deceased and PW4.
Initially, on 24, one day earlier, it was borrowed.
Yes.
A1 and A4.
Yes.
This, the incident has taken place in this manner according to the prosecution. That's-
Yes.
These are the facts. The prosecution is examining 16 witnesses. 1 to 7 are evidence.
Yes.
And 2, 3, 5, 6, 7 are injured evidence. Now, after this incident, which occurred at about 11 p.m., the injured and deceased, they were removed to Malur Hospital. Malur Hospital, they were there. Since deceased was not conscious, he was taken to Niman. The injured were treated and they were discharged.
Yes. They sustained grievous injury, simple injury. All. Yes.
Similar, the deceased was taken to Niman. And the next day, he was brought back from Niman.
Yes.
On the way at about 7 p.m. he dies. Now, when they were taken to the hospital, the police were informed and then they come to the
Who is the informant? Who is the informant? Who lodged the complaint?
PW1 takes only injured and deceased along with others to the hospital. Police come there, but no complaint is lodged. Next day at about 10:30 a.m. Next day at about 10:30 a.m. First information is lodged, this complaint is lodged. Exhibit P1 by PW1. Then of PW4. On the basis of Exhibit B1, case is registered as 9%.
Hmm.
7 o'clock, this is Apayappa dies on the way from Imam school.
Yes.
And at 9 p.m. where the other complaint is brought. That is exhibit P11.
After death.
After death. So section 302 is.
Now, why he was brought back? Why he was brought back from the hospital?
According to P1, his condition was very serious. There's no chance of his surviving. Therefore, he was brought back. That's what P1 says. There's no other material why he was brought back. Except statement of P1. And at this stage, I mentioned that exhibit B1, the real author is one Krishna, brother of P1, who is a student studying in BCom. He is not examined. PW1 has only lent his signature. The real author of exhibit B1 is not examined.
At the instance of PW1, that was written.
At the instance of PW1?
Yes. And PW1 supported the case.
PW1 has supported. Whether at the instance of PW1 or on his own, Krishna has written, that is not.
You have not cross-examined. You have not cross-examined.
He has not said that on my inscription it was written. He only says that it was written by my brother. It's not a major informative, but it's an informative. This is the prosecution case.
Yes.
16 witnesses have been examined. There are 1 to 7 are eyewitnesses. And 2, 3, 6, and 7 are injured eyewitnesses. Then, PW8 is bench witness. That is partner.
Yes.
PW9 is inquest bench. And PW10 is a witness for the Maza seizing weapons, offenses from A3, A4, A5, and A7. PW11 is punch for the seizure of bloodstained notes.
Yes.
PW6 and 7. PW12 is doctor who has treated PW6 and 7 and also conducted autopsy.
Yes.
Then PW13 is HC was given a requisition to add section 302. Then PW14 is sub-inspector who is registered the case and conducted part of the investigation. PW15 is the doctor who has treated 2, 3. PW2 and 3. PW16 is IO who has completed the investigation by the charge.
Yes.
But very first information.
ಆಯ್ತು ಅದೆಲ್ಲ ನೋಡಾಯ್ತು. Yes. Now directly come to the evidence. What are the grounds you are urging? Sir, what are the grounds on which you are challenging the impugned judgment? Why are you challenging that?
The motive of the prosecution is quarrel between accused number 1 and according to the prosecution, now the accused, they go to the place of the case.
Sir, I am not asking you the facts. I am asking you what are the grounds? What made you to challenge the impugned judgment?
So that's what
Precisely, what are the grounds? Ameli, you can elaborate on that.
according to the prosecution,
Hmm.
that there was no intention, no reason for assaulting the deceased. It has happened accidentally.
There was motive.
So the motive according to the prosecution
Hmm.
is to assault PW4.
Hmm.
PW4 was very much available there.
Yes. And she
It is not that.
even he sustained injuries.
No, PW4 has not sustained it.
PW4 was inside the house.
But inside the
It
house,
it was the deceased who opened the door
deceased opened the door.
and received the
Received the injury.
quite
That-
natural.
It had nothing to do with the deceased.
Quite natural.
Nothing to do with the deceased.
Hmm.
And he says A2 assaulted him.
Hmm.
Then after the deceased falls down, others comes out.
Yes.
The others could not have seen him, seen deceased being assaulted by A2.
Hmm.
So their evidence cannot be believed. PW said that PW1
Hmm.
will be complained. This is what he says. Two admissions are expected from his evidence.
Hmm.
At page 63. Basically, paper book.
Hmm.
Paper book.
ಸರ್ ಪೇಪರ್ ಬುಕ್ ನೋಡ್ತಾ ಇಲ್ಲ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
Original page 4.
ಎಸ್.
Last paragraph. I am studying in second year PUC at government junior college model. The contents of the activity are not in my handwriting. The contents of it are in the handwriting of my other brother. I affix my signature to mother's station. At page 6 million.
Yes. Hmm.
Line about 7.
Hmm.
I told the doctor that there was Karnataka, but I did not tell the names of the asylum.
Yes.
Then look at page 66. Second paragraph. Line about
66. 66 ಅಲ್ಲ ಸರ್ ಇನ್ ಪೇಜ್ ಹೇಳಬೇಕು.
7 page. Page 7.
Hmm.
Page 7.
Hmm.
Second paragraph. Line 5.
Hmm.
There was no ill will or quarrel between Appayappa and his family members on the one hand and the accused on the other. As relative. Appayappa is, I do not know, support to many countries. This by PW1.
Hmm. Whether motive is necessary. Whether motive is necessary.
Motive is irrelevant.
Whether it was necessary.
It's necessary in this.
When there are eyewitnesses to the incident.
In a case of this type.
When there are eyewitnesses to the incident.
It's absolutely irrelevant factor.
Sir, without any motive, a person assaults the other one and causes his death.
Then now, what I am submitting,
Hmm.
so whether eyewitnesses can be believed on this type.
Hmm.
Whether The eyewitnesses have really seen.
Sir, position of law is that when there are eyewitnesses, motive loses its importance.
Loses its importance.
Yes.
It will not be as important as it would be.
Yes, that is what.
That is true.
Yes.
It is, whether it is case based on direct evidence or indirect circumstantial evidence. The fact remains it's a relevant fact. Motive is relevant. It cannot represent that. If there is absolutely no motive. Say, the evidence of the eyewitnesses should be set. Should admit be no doubt. It's one of the circumstances which you are wanting to take into consideration. By considering the evidence of eyewitness.
Then.
And we are at page 10. Page 10, paragraph 3. On hearing the accused shouting Apayappa, first came out of our house. After hearing the screams of Apayappa, we came out from our house. We were in our house for about 3/4 of an hour. After Apayappa sustained injuries during the said 3/4 of an hour, no person from the neighboring houses came out. And this statement, this evidence of beautiful one would show that they have not seen accused number 2 or any other person assaulting Apayappa. They have come after Apayappa sustained injury and fell down.
After hearing the screams of Abhayappa, we came.
We came. Apayappa fell down according to the prosecution after he was assaulted.
ಆಯ್ತು ಇಲ್ಲಿ ಎಲ್ಲಿದೆ ಆ ರೀತಿ.
So that is what the inference is that.
See, he has deposed as much as 11 pages of deposition is there. We cannot infer so many things. There must be clear cut to brand it as an admission. It should be very clear.
In a case of this time, when it's capable of the one which is in my favor.
Of course, that is the settled position. That is the settled position. Whether that can be applied here.
This evidence and PW 2 also says that page 3, we had lined the doors of our house. Page 3, page 3,
Yes. PW2.
PW1 is concerned. I submitted to that PW Krishna with whether PW1 is the real author of Exhibit 3-1 and PW1 was only lent his signature. The second complaint he gives after the death of there he does not say that his PW was ordered.
Sir, already FIR was registered. It is only an intimation.
Yes.
That cannot be termed as a first information.
It's not first
Only for one first information will be there.
It's not first information.
Yes. That is the intimation of death of the injured.
He gives a detailed complaint. Detailed complaint again.
Yes.
In which he does not say.
Even then, that will not assume the character of a first information.
And that in the second complaint, in his complaint, he would not mention about age of traffic. And in the evidence, he admits that after hearing the scream, others come out of the court. It was 11 o'clock in the night. There was no email They had nothing to do with the disease.
If there was no ill will, and if you have nothing to do with that, why you have gone to the house of the deceased?
Some incident has taken place. I am not disputing.
So your presence is not disputed.
Say who are present, who are not present, it's not clear. It looks like.
No, presence of the accused is never disputed.
It looks like not that there was some one of the two parties.
Maybe the presence of the accused in the house of the deceased is not disputed.
Now whether the prosecution, the accused presence, say maybe true or may not be true.
ಆ ರೀತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಇಲ್ಲಿ. Already trial has concluded now. That is why I am asking you, after going through the cross-examination of PW1, you never disputed your presence in the house of the deceased at the time of incident. In other words, you admitted your presence in the house of the deceased at the time of incident. If there was no ill will, if there was no motive, why the accused have gone to the house of the deceased at the dead night, armed with weapons?
Then that motive was against accused number 324.
They are all family members, sir. They are all family members.
They are from different religions. They had nothing to do with that.
PW4, how PW4 was related to the deceased?
PW4's deceased son had married PW4's daughter. That is PW3.
Yes.
Had married PW4's daughter. PW3 is son of this.
Yes. So.
They had come to be some purpose. That particular time.
Yes.
This has happened.
Happened. Yes.
And no reason to assault or do anything to the deceased.
That is why. That is why the trial court convicted you for not 302 but for 304 part 2. ಅಷ್ಟೇ ಅದೊಂದೇ reason.
That's true. If your lordship believes, so what the witnesses are saying is true.
No, why they should not be believed ಅನ್ನೋದು ನೀವು ಹೇಳ್ಬೇಕು ನಾನು. Otherwise I am bound to believe.
That's the reason I am submitting. Please take this admission of the item PW1.
That is not the admission. That is not the admission. Admission must be very unequivocal and clear. Everything cannot be the admission. It is very settled position. To brand a deposition as an admission, it must be clear and unequivocal. ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಎಲ್ಲ ಓದೋದು it is an admission. No. It should satisfy some conditions.
This is what he says. On hearing the accused shouting, fire first came out of the house.
Yes.
After hearing the screams of fire, we came out from the house. We were in our village for fire persisted injuries. This should clearly show, it's unequivocal. It is clearly show that after Apayappa fell down, these people came.
No, he never says he had already fell down. He screamed ಅಷ್ಟೇ.
He fell down and he screamed.
Fell down ಅಂತ ನೀವು ಸೇರಿಸ್ತಾ ಇದ್ದೀರಿ. Fell down ಅಂತ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ? Read it for 10 times. The witness never says he had already fell down.
This witness cannot say that after he fell down, so we came to know. So he only said that he was screaming.
ಅಷ್ಟೇ.
Screaming means he had been assaulted.
Yes. Assaulted.
That's over. Who assaulted?
Not over, sir. The deceased had sustained 3 or 4 injuries. as per the PM report. Yes. Was it not necessary to cross-examine the witness? There was only one blow. Other injuries are corresponding injuries. Where are the cross-examination? Oh, so we have to presume everything. It is not a question of presumption or assumption. There must be evidence.
And let PW2 says this.
Cross-examination you are saying? Yes.
Last 3 years, we had 90 doors of people from inside. Apayappa opened the latch and the door. Immediately after Apayappa went out from a home, he was assaulted. And thereafter, the remaining of us came out. This is another statement which corroborates my submission. And everyone has also said blood half an hour, 45 minutes. So nobody, either came to the place. That would show that the presence of accused number 6 and 7 at the time Apayappa received it. Then another witness.
Sir, PW2 is the injured eyewitness. It assumes importance. His deposition cannot be brushed aside. See, in his chief examination, he has clearly described how the incident had occurred. Accused number 2 assaulted Abhayappa with the club on his head. Accused number 7, Venkatesh, assaulted me with the club on my right hand. I sustained fracture of my right hand. Accused number 3, Rajappa, assaulted CW so-and-so Venkatesh with the club. Accused number 4, Srinivas, assaulted CW6 with club. Accused number 5, assaulted CW7 with a knife on his face. Accused number 8, assaulted accused number 9 and CW5 Sitama. Is there any cross-examination to this portion of the evidence? No.
This is so far as I am concentrating only on accused number 2's case.
Yes, he says accused number 2 assaulted the Abhayappa with the club on his head. Yes.
The cross-examination says after he was assaulted, after he fell down, then they came out.
No. After hearing the scream, we rushed to the spot.
That is what PW1 says.
Yes.
And PW2 says.
Who stated that only after receiving the fatal blow he screamed? He must have screamed immediately after opening the door. That is why I said there must be clarity.
No, Apayappa opened the door. Immediately after Apayappa went out, he was assaulted. Thereafter, the remaining of us came out.
No. On those flimsy grounds, the accused is not entitled for acquittal, sir, because you are not disputing your presence, first one, at the scene of occurrence. And moreover, admittedly, Abhayappa died due to the injuries sustained on his head. The doctor has also given, PM report is also there. The doctor has given his evidence. And moreover, PWs 2, 3, 6 and 7 are the injured eyewitnesses. They speak about the incident. PWs 1, 4, 5 are the eyewitnesses. In the chief examination, if you go through their chief examination, they have specifically stated about the overtax committed by the accused. Simply because they say after hearing the scream by the Abbayappa, we came to the spot, does not automatically to conclude that they came to the spot after assault. No, you cannot.
They come out of the house.
Yes, yes.
They come out of the house. Obviously, they are not saying that's all they do.
No, I don't admit your contention. That cannot be, because you cannot ignore the chief examination. Of course, if you have elicited from the witnesses during cross-examination that we have not seen, but before we are coming to the spot, the Abbayappa had already fallen down. We do not know who had assaulted. You are right. But here it is not so. That is why the cross-examination is there. No, that will not create doubt, sir. That will not create any doubt. No, that is not the possible defense or plausible defense. No. Next. That is why I asked you what are the grounds on which you are challenging the impugned judgment. Because there are so many injured eyewitnesses, and the incident had occurred. Yes. That assumes importance. Incident you are not disputing. Your presence at this scene of occurrence you are not disputing. You have not disputed. You have not disputed, that is what I am saying. You have not disputed that.
I don't have to put that kind of question to every witness. I can make out that that's my stand on the basis of the prosecution case itself.
Yes.
That's what I am doing.
Yes. Proceed.
I'm going to PW3 I did page 3.
So all the witnesses have stated that after hearing the scream, we came to the spot and the accused have assaulted us.
PW3 with the son of deceased. He also says that page 5, accused person in this case have no usage against my parents, my family members, myself. And nothing to do.
Yes.
Absolutely another thing. There must be some reason for that.
Sir, motive against accused number PW4. PW4.
PW4.
Yes. PW4 was inside the house.
Inside the house.
Yes.
He comes out.
Yes.
He comes out. They're not even touching.
Yes. If your argument, this argument you could have addressed if you are convicted for the offense 302. That is why 304 ಮಾಡಿದ್ದಾರೆ. Only 5 years ಕೊಟ್ಟಿದ್ದಾರೆ, otherwise life ಆಗ್ತಿತ್ತು.
Before also said.
Yes.
Cross-examination. Second paragraph. came out from our house, Apayappa had fallen down.
Yes, yes.
And he also says, next page, first line. At that time, no neighbor came to the scene of offense. I volunteered and said, they were all sleeping at that time.
Yes.
That is, PW, this falsifies the evidence of PW 6 and 7, who also include witnesses of having seen.
How they received injuries then? How they sustained injuries? How they sustained injuries?
They have received injuries. They have come to the spot. After Apayappa fell assaulted, been assaulted.
How they sustained injuries if they were not at this spot?
They have received injuries in the incident. So far as A2 is concerned, A2's act. All the four witnesses, they say that after Apayappa had fell down, they come home.
PW 6 and 7 are the neighbors.
According to PW 1 and PW 4, say they come at a later stage, they try to intervene, then they must have received the injury.
So till they came and intervened, the incident was going on.
Incident was going on. It says PW 7 specifically says.
Yes, it is.
It's a quarrel which is going on between the accused and
it is not as if the accused have assaulted, inflicted one blow on Abhayappa and went away. They were there. They assaulted the other witnesses.
So there was a quarrel.
Yes. Yes, next.
And PW 5, she says, it too. Before this, they have not told anybody, including the police.
Yes.
So the first time PW 5
Yes.
not included. Wipe out. See. So this statement makes an unbelievable for the first time after many years. PW 5 PW 5 Apayappa opened the door, the house for PW 1 first time. Apayappa opened the door of the house of PW 1 and came out. Accused number 2 assaulted Apayappa with the gun. So this statement is omission. He has not stated that at page.
Whether the attention of the witness was drawn to the statement?
Page 2 last line. It is false to say that I have not stated in my statement that this is Apayappa opened the door of the house.
Yes.
I was PW 7. In chief examination itself. We heard line 2, we heard 13 people, PW 6, Rajkumar and myself went near the house of PW 1. At that time, family members of PW 1 operation one side and the accused person in this case, on the other hand, were quarreling with each other. There's a quarrel.
Yes.
In that one of this incident is taken.
Hmm.
That not the case of the prosecutor.
Yes.
And the target of the accused persons according to the prosecution.
Hmm.
The PW4 has not been touched.
ಆಯ್ತು ಅದೆಲ್ಲ ಹೇಳಾಯ್ತು ನೀವು motive, there is no motive. Yes.
No motive.
Yes.
This has,
And they are then not the eyewitnesses.
this has, the eyewitnesses cannot be revealed.
Yes.
But this is.
Then. Hmm.
So therefore, there is no credible evidence to show that two was not.
Hmm. Hmm. ಆಯ್ತು.
And then the finding of trial court. Then page 44.
Yes. Hmm.
Page 44.
Yes.
Once I have come to the conclusion that the unlawful assembly consists of come up there, I will ask this better injury to apply for including sustaining of an injury to apply was an accidental. So it is to be considered with all the members of the church.
Yes.
Then the trial court has also come to the conclusion that it's an accidental assault.
Hmm.
Then
Yes.
at page 54.
Hmm.
Paragraph 72.
Yes.
Since none of the accused were members of such assembly had any intention to cause any injury to PWC or any other injured person. In this case, section 149 cannot be invoked to hold that even the other accused are going to set up and
Hmm.
then page 63.
Yes.
Line about 5 from bottom.
Sixty.
63.
Yes.
Line about 6 from bottom.
Hmm.
There are no common object either to not just apply
Hmm. Yes.
PWC 6 and 7 have been examined, though they were in hospital.
Yes.
On 25th itself, 25th night. First information is not next day.
Yes.
On 26th, they were all the witnesses, including injured witnesses at the hospital, and the police had come to that place. No complaint is lodged and no statement is made by any of these witnesses.
Yes.
PW 6 and 7 in particular have been examined on 5/9, that is after 12 days, 11 days. So the delay in examining these witnesses that itself evidence doubt. And as I submitted already with the August PW4, he is not that. PW1 is not that. That is PW5, PW6, 7, 3.
What about the wound certificates? Wound certificates?
Wound certificate page 5, exhibit 5, 6, 14. Paper book is the page.
Date of incident 24th or 25th?
Date of incident 25/8.
Yes. Same day they were taken to hospital.
Immediately they were taken.
Yes. Yes.
Well, the PW6 has sustained one laceration. PW7 has one lacerated wound with 5 centimeter by half centimeter. PW7 has
Exhibit P5 pertains to PW6. Exhibit P6.
has sustained one lacerated wound below the right eye and swelling with right mid. So this is described by the doctor as first injury is liver and second injury is
No, exhibit P5 pertains to PW6. That is, there is only one injury, lacerated wound.
and PW6, exhibit P6 pertains to PW7.
7.
Yes,
One grievous injury, one simple injury.
This is the judges described, considered this aspect and said it's not grievous, it is simple. That's why intermediate.
Yes.
Does not come within section.
Yes.
And PW14. PW2. PW14. Sorry, PW14.
PW2 now.
One hematoma. PW15. Sorry, another one.
PW3.
PW3. Hematoma measuring 2/2. Fingernail operation. Operation.
Yes.
Sudden call, this is the assault and this is fire. It's no acceptable evidence. It looks like just take witnesses have come to this court after.
ಆಯ್ತು ಅದೆಲ್ಲ ಗೊತ್ತಾಯ್ತು ನನಗೆ. Only with regard to accused number 2. What about the other accused?
So far as accused number, others are concerned with the delay in examination. Incident is said to have taken place. 11 p.m., 10:30 or 11 p.m. So they had absolutely nothing to do with PW3, PW6 and PW7. PW2 has suffered one control. Their statements have not been recorded immediately. Complaint has been lodged next day. Statement of PW7, 6 and 7 examined after 7 days. No reason is required.
Who is at fault? Who is at fault for not recording the statements of the injured witnesses?
No explanation is given.
No, who has to record it? Lapse on the part of the investigating officer, can it be advantageous to the accused? What is the position of law? I am asking.
Normally it will go in favor of the accused.
Okay.
If the evidence of those witnesses is trustworthy.
See, they are not the simple eyewitnesses, they are the injured eyewitnesses. Immediately after the incident, they were admitted to the hospital and police intimation is there. Exhibit. Exhibit P11.
Exhibit P11, no mention is made of assault by A2. And as far as others concerned, an omnibus, all embracing statement.
Yes.
This is one part of it. If you are some incident has taken place and therefore some have to do. There may be individual liabilities fixed to all of them.
What is the time of, it was date of offense 26th.
At 25, date of offense is 25/8. At about 10:30 or 11 p.m. Police were very much there in the hospital. Witness, if they go to the hospital, police station first, statement is not recorded.
Yes. Hmm.
Target was going to be opposed. It's not that target was going to be injured as well as disease. They had nothing to do with it. It's an accidental by chance. It happened.
That is why 304 was invoked for 2.
My alternative
ಆಲ್ಟರ್ನೇಟಿವ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಬೈ ಚಾನ್ಸ್ ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಹೋಮಿಸೈಡಲ್ ಡೆತ್ ನಾಟ್ ಅಮೌಂಟಿಂಗ್ ಟು ಮರ್ಡರ್. ಹ್ಮ್. ಹ್ಮ್.
Others are undergone 18 days and they were paid. Egypt is a great place of sentence of fine to 18.
Maybe co-accused I may consider, but not accused number 2. He inflicted fatal injury.
It has happened accidentally.
Cannot be, sir. Accidentally in ಯಾರ್ಯಾರದ್ದು ಕೇಸ್ ತೆಗಿಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ.
Fine may be, so far as A2 is concerned, say fine may be.
No.
Substantive sentence will be restricted.
No. ಎಷ್ಟಿದೆ 304 2ಗೆ?
10 years.
Now minimum what is the minimum ಎಷ್ಟು?
Minimum.
10 years.
Minimum.
Hmm. But imposed 5 years. Either description.
Okay. It can be one. It may extend to 10 years or with fine or
Hmm.
it can be even fine.
Yes.
Substantive sentence may be increased.
There must be some reasons, sir, to increase that.
Incident has taken place in 2012. They had nothing to do with the man.
Sir, the incident had occurred in the house of the deceased. You had gone to his house, made him to open the door, and thereafter assaulted. Yes, he was there. At least PW4 house ಗೆ ಹೋಗಿದ್ರಲ್ವಾ? ಏನ್ ಸುಮ್ಮನೆ ಕ್ಯಾಶುಯಲಿ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ರಾ? Yes. No. You are answerable to the death of the deceased. ಅದು ಒಂದು ಲೈಫೇ ಅಲ್ವಾ ಅವನದು? For no fault of his he died. Who is accountable for that? And consistently all the witnesses have deposed. And the evidence of injured eyewitnesses cannot be ignored so lightly. And since it is in the house, the inmates of the house are the natural witnesses. Their evidence cannot be disbelieved. ಅದೆಲ್ಲ ಬಿಡಿ ಸರ್, ಅವೆಲ್ಲ ಹೇರ್ ಸ್ಪ್ಲಿಟಿಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಬರಲ್ಲ. ಓಕೆ, ನಾವು ವಿ ಆರ್ ಆಲ್ರೆಡಿ ಕನ್ವಿಕ್ಟೆಡ್. Before the trial court, you can take a chance by addressing such arguments, not before the appellate court, when the trial court has already convicted.
So far as sentence is concerned,
ಇದು ನಿಮ್ದು ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಇದಾಗಿದ್ದಿದ್ರೆ ಐ ವುಡ್ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್, ನಾಟ್ ಆಫ್ಟರ್ 1.5 hours of argument.
I must note it. It's a mood of the court.
Yes.
I cannot straight away. This second page, I can be.
Mood of the court ಅಲ್ಲ, that is a discretion, not the mood of the court. Judicious discretion. ಅದಕ್ಕೆ ಮೂಡ್ ಅಂತ ಹೇಳಲ್ಲ. ನಾವು ಮೂಡಿಯಾಗಿ ಇಲ್ಲಿ ಬಂದು ಕೂತ್ಕೊಳ್ಳಲ್ಲ. Otherwise, I would not have allowed you to address the argument for more than an hour. No. I heard it patiently. I noted down. ಮೂಡ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. I would not have allowed you to address the argument.
I was prepared to go to
Yes.
I had addressed.
Yes.
I had addressed.
Yes. I am not finding fault with you. On merits, I am finding fault with you. There is no wrong in the advocate addressing the argument. Nothing. You are having the right. You can address it. And patiently I heard. Have I interrupted? No.
If I had addressed it, if I had made this sufficient beginning at the outset, the worship probably would have been my then that benefit against.
No.
The mistake I made.
No. There is no mistake, nothing. There is no mistake, nothing. You have done your job. Allow me to do my job first. Yes, what do you say regarding leniency in sentence? Unlawful assembly already acquitted, sir. Trial court has acquitted. You have not preferred any appeal. Common object, unlawful assembly, writing, everything. The trial court has acquitted. Only 304 part 2 and 324 conviction. How many days accused number 3 to 5 and 7 were in custody? Only 18 days. And what about accused number 2?
1 year.
1 year, 15 days. Anything else? What was recovered at the instance of accused number 2? At whose instance the weapons were recovered?
And PW1 says that all the weapons were found in the spot.
At the spot, not somewhere else.
PW1.
Yes, sir. Caesar Mahzar
PW1 is not mentioned. He says the weapons were.
No, according to the investigating officer, where he recovered. What are the weapons recovered at the instance of the accused?
A3, A4, A7, and A5. Glove, chopper, glove, and knife.
No, accused number 3.
Accused number 3, glove. Accused number 4, chopper. Accused number 7, glove. Accused number 5, knife.
Recovered under exhibit?
Exhibit B4.
ನೀವು ನೋಟ್ಸ್ ಗಿಟ್ಸ್ ಏನು ಮಾಡಲ್ವಾ? ಎಲ್ಲಿದೆ? ಮತ್ತೆ ಇಷ್ಟೊತ್ತು ಯಾಕೆ ತಗೊಳ್ತೀರಿ? ಏನಾರು ಕೇಳಿದ್ರೆ ಎಷ್ಟೊಂದು ಹುಡುಕ್ತಿರಲ್ಲ ಯಾಕೆ? Even after hearing his argument, lengthy argument, you are not in a position. ಇನ್ನು ಡೀಟೇಲ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಅಂದ್ರೆ ಕ್ಯಾನ್ ಯು ಡೂ ದಟ್? These facts should be at your fingertips. ಈ ಕ್ಯಾಶುವಲ್ ಅಪ್ರೋಚ್ ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ. ನಾ ಮೊದಲು ಹೇಳಿದ್ದೀನಿ, ಯು ಶುಡ್ ಕಮ್ ಪ್ರಿಪೇರ್ಡ್. ಐ ಕೆನಾಟ್ ಅಸ್ಯೂಮ್ ಯುವರ್ ರೋಲ್ ಆಸ್ ಎ ಪ್ರಾಸಿಕ್ಯೂಟರ್. He has raised so many questions. What is your answer? According to him, none of them are the eyewitnesses. He has explained why he is saying so. They are the eyewitnesses to the injuries sustained by them, not for the injuries sustained by the deceased. We came to the spot after hearing this scream.
She has very clearly stated that there is no cross-examination on that aspect.
What she has stated? ಮತ್ತೆ ನೀವು ಹುಡುಕಬೇಕು, ನಾನು ಕೂತ್ಕೋಬೇಕು ಇಲ್ಲಿ. Come prepared at 2:30. Which one, sir? Which one? Which one? Which matter? ಆಯ್ತು, ಅದೆಲ್ಲ ಜನ ಆಯ್ತು. Amicus ಆಯ್ತು. Next. Which one? They are in custody, sir. When will you argue? Tomorrow, stay. No further date.
My lords,
No, nothing.
my lords, I appear for serial number 5, my lords, in list 2. My lords, I'm taking a short accommodation on the ground.
Come at 2:30. Come at 2:30. ಯಾವುದಿದೆ 35 ನಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ Amicus curiae ಆಗಿಲ್ವಾ ಹಾಂ ಅದಿರಲಿ ಒಂದು ನಿಮಿಷ ಮತ್ತೆ ಅದು 20 ಅದು ಬರುತ್ತಲ್ವಾ ಅದಾಯ್ತು ಮತ್ತೆ ಬೆಳಿಗ್ಗೆ ಯಾವುದೊಂದು ಮತ್ತೊಂದು ಬಂದೇನೋ ಅನ್ಸುತ್ತೆ. Hmm, 39 correct. I will come back, 1 minute. Accused number? In all, how many accused? Hmm.
12, 13, 14, 15, and 16. I will granted bail by exam before or before.
Yes.
But accused number 11 and 12 not. Accused number 11, 12, and 13. Similarly, placed with that of the disaccused person. According to this case of the prosecution.
When these petitioner appellants were arrested?
2 days after the incident.
When?
Last 1.5 years.
Date?
On 6/5/2024.
Charge sheet is filed.
Charge sheet is filed.
In our offense?
According to the prosecution word, 302, 307, 143, 147, 149, every section B1, B1S of Atrocities Act. But so far the Atrocities Act is concerned, it doesn't constitute an offense under section atrocities for the simple reason that here we see of 4 accused persons who belongs to SC/ST having category. Subsequently, the FIR not their names were omitted and they are not being named as accused in the FIR. Then the complaint was filed earlier. Subsequently, after investigation, the police, after investigation, they are the persons who belongs to atrocity and SC/ST community are being added as accused in this case.
They are also accused.
They are also category. Accused number 12 to 16 belongs to SC/ST. As such, they could not have been assaulted for the reason that he belongs to a federal caste.
What is the overt act alleged against you?
Overt act alleged against him. Accused number 7, he assaulted the deceased with a oval pipe on his knees, on his legs. So far as accused number 8 is concerned, Nilgiri Kadiyali, he assaulted on the right shoulder of the deceased. What this incident of assault on the person of the complainant?
No, accused number 7 assaulted with a pipe on
Knees on leg, ಕಾಲ್ ಮೇಲೆ ಹೊಡೆದ್ರು.
ಯಾರ ಮೇಲೆ?
Deceased. Accused number 8, the second petitioner, assaulted the deceased with a Nilgiri stick on his right shoulder. That's the allegation.
Yes.
But the accused number 13, 11,
12.
They are also similarly placed to that of this accused person. But one thing, at this point of time, I would like to bring to my lordship kind notice. But for this reason, I am bringing this into my lordship kind notice. The deceased was a rowdy cheater, and
there was more than 30 cases filed against him, not only in state of Karnataka but also in state of Andhra Pradesh.
1 minute. What is that?
But this deceased person, Mr. Amrish,
Hmm.
there are more than 30 cases registered against him, not only in the state of Karnataka, but also in the state of Andhra Pradesh. For this reason, I am making this submission. He has more enemies than friends. For this limited purpose, what I am trying to
That cannot be the ground to cause his death.
that's exactly what.
Hmm.
My God, can you permit me to affirm this?
ಆಯ್ತು ಇರ್ಲಿ simply because he is a rowdy sheeter you cannot cause his death.
That's exactly not the simple reason, but he has more enemies than friends.
Enemies ಇರ್ಲಿ but why you have caused his death?
Witnesses say like he has been done to death by some other persons, and
CW2, CW2, 3, 4 are the eyewitnesses.
No, we are not. That's exactly not. There are two incidents. One happens at Ashwatthate in the village itself. There, not CW, the complainant CW1 and his relative came to be assaulted by the few of the accused persons. But only you accused of the complainant and CW2, 3, 4 are the eyewitnesses.
Incident that incident, when that incident had occurred?
In Nilgiri
on the same day.
On the same day, subsequently after away from that.
Date of incident ಹೇಳಿಪ್ಪ.
Same night after 2/5/2024.
Like this earlier incident is on 2/5/2024 at what time?
At around 9 o'clock.
Morning.
In the
Night. 9 p.m.
8 or 9, in between 8
Aye. Second incident.
Around, no one knows the exact period.
But when?
On the very same day at midnight, he runs away according to the case of prosecution that deceased Amisha, after he being assaulted there in the near Ashwatthate, he runs away from the place of incident. But the injured person was being the complainant and is another relative.
Where, have you produced the order granting bail to accused number 11 and 12?
These are the two orders.
ಕೊಡಿ. against whom similar allegations are made.
Article 2 to 6 is design guidelines.
ಅದು ಆಯ್ತು ರೀ 11 and 12.
ಅದರಲ್ಲಿ CH-20 ಮತ್ತೆ ಅವರಿಗೆ grievance injury ಅಂತ ಅದರ
11 is not the SCST. No. According to him, only accused number 12 and 12 to 16. 11 is granted bail. Sir, page number is amel barana. The allegation made in the charge sheet, accused number 11 assaulted with iron rod and pipe on the legs of the deceased. What is the allegation against these petition appellants? Similar allegation. They have assaulted with a pipe on leg, assaulted with a club on the right shoulder. Similar allegations in the why they are not entitled for parity. Adirli. Yes, what is? Sir, I am not about the seriousness of the offense. Yes, there are serious injuries. Everything is right.
One is also one injured witness.
CCP, please understand. He is also not understanding. You are also not understanding the question. I am not on any other point. The co-accused are already enlarged on bail. Similar allegations were made against them. Under such circumstances, why the appellants are not entitled for the benefit of parity? ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇರೋದು ನಾನು. ಬೇರೆ ಅಲ್ಲಿ ಇಂಜುರೀಸ್ ಆಗಿದೆ, 32 ಇಂಜುರೀಸ್, ಸೀರಿಯಸ್ನೆಸ್ ಆಫ್ ದ ಅಫೆನ್ಸ್, ಡೆತ್ ಆಗಿದೆ, ಎವ್ರಿಥಿಂಗ್ ಅಡ್ಮಿಟೆಡ್. Yes. Have you challenged the order granting bail? No. Togoldi. Appellants being accused number 7 and 8 in so and so for the offense punishable under section so and so are seeking grant of bail. Third so and so. Here is the material. Point for consideration. I answer to the above point in the affirmative for the following reasons. The appellants are arraigned as accused number 7 and 8 in the charge sheet filed for the offense against for the offense under section so and so. The appellants were apprehended on 6/5/2024 and since then they are in judicial custody. Serious allegations are made against all the accused 1 to 16 for having committed the offense, including the offense under 302 of IPC. According to the charge sheet filed by the investigating officer, there are eyewitnesses to the incident. Next part. When counsel for the petition appellant has produced the orders granting bail to accused number 11 as per the charge sheet, accused number 11 and 12 assaulted the deceased with iron rod and pipe on his legs. It is stated that accused number 12 is also enlarged on bail. So also accused number 13, 14, 15 and 16. On going through the charge sheet, it is alleged that accused number 7 assaulted with a pipe on the leg of the deceased and accused number 8 assaulted with a club on his right shoulder. Therefore, the overt act alleged against accused number against the appellants herein and accused number 11 and 12 are similar. Then counsel for the appellant submits that accused number 11 does not belong to SCST. Even the provisions of the special enactment were invoked against him, and in spite of that, he was granted bail. This fact is not disputed either by learned HCGP or by the learned counsel for respondent. Admittedly, the respondents have not challenged granting bail in favor of accused number 11 and 12, who are similarly placed. Considering all these facts and circumstances, I am of the opinion that the appellants are entitled for grant of bail on principles of parity. Reasonable conditions may be imposed. Any criminal antecedents? It is not the contention of the prosecution that the appellants are required for further investigation or that they are having criminal antecedents. Reasonable conditions may be imposed while enlarging them on bail. Yes, subject to conditions allowed.
Serial number 25, H. Bhagwan.
Serial number? Viruddha. Yes. Hmm. 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 Accidentally ಏನಿಲ್ಲ, you deliberately gone there armed with a club. Made him to open the door, assaulted him. Then under which provision it falls? 320 death agide sir. Death agide within no time he died. 326 ಆಗಿ ಬರುತ್ತೆ.
Intentionally causing death or intentionally causing such bodily injury which is likely to cause death.
300 ತಗೊಳ್ಳಿ, ಓದಿ ಏನಿರುತ್ತೆ. ಸೆಕ್ಷನ್ 300 ಓದಿ. $220, $299 ಓದಿ. $299.
Whoever 299.
Yes.
Whoever causes death by doing an act with the intention of causing death.
Yes, proceed. It does not stop there.
With the intention of causing such bodily injury as is likely to cause death.
Yes. Yes.
With the knowledge that is likely
Yes, even when there is no intention, with the knowledge that he is likely by such act to cause death. Here where you fall. Intention was not the
all this
knowledge. It is a common knowledge. When a person is assaulted on the head.
shot in the car. Incident is taking place.
No, nothing. ಅವೆಲ್ಲ
Again,
no. Nothing. You have not addressed anything about accused number 357.
So there we are also saying injuries and symptoms
I do not find any reason to show any leniency, sir. Maximum leniency is shown by the trial court. Yes, what do you say? Now we are asking you regarding reduction of sentence. ನೀವು ಸ್ವಲ್ಪ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಮೈಂಡ್ ಬೇಕು ಸರ್. ಯಾವ ಲೈನ್ ನಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಯಾವ್ದು ಕೇಳ್ತಾ ಇದೀವಿ ಅಂತ. ಎಮೋ ರಿಕವರಿ ಎಲ್ಲ ಆಗೋಯ್ತು. ರಿಡಕ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್, ವಾಟ್ ಡು ಯು ಸೇ? Why?
He is the main person who started on the head of the disease.
You heard his argument. What is your reply? What was his contention? Tell me. ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. Main contention raised by him. There was no intention that was accepted by the trial court.
They had the intention to kill PW4.
Yes.
And this time,
So they were not having any intention to cause the death of the deceased.
That's what 304B. So that is
12 years have already lapsed. He was in JC for more than 1 year.
5 years only.
5 years ಅಲ್ಲಿ minimum sentence ಇಲ್ಲ 304 ಗೆ. Maximum 10 years. Or even life, I think. Alva? Maximum.
Can we also find with the knowledge that it is likely to cause death, but without intention to cause death. Or cause such bodily injury.
What will be the, if the set off is given, what should be the fine amount? 1 lakh. Death ಪ್ರಾಣ ಹೋಗಿದೆ ಸರ್, ಪ್ರಾಣ ಹೋಗಿದೆ ಒಬ್ಬರದು. 1 lakh ನಲ್ಲಿ ಜೀವ ಬಂದ್ಬಿಡುತ್ತೆ. ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂದ್ಮೇಲೆ ಮುಚ್ಕೊಂಡು ಮನೇಲಿ ಇರ್ಬೇಕು. ಹೋಗಿ ಅವರಿಗೆ ಮನೆಗೆ ಹೋಗಿ ಹೊಡೆಯೋದಲ್ಲ. Think about the person who has lost the life of his near and dear ones.
When they were asserted to his wife and son also, while reading also they are reading the deceased. They are asserted.
5 ವರ್ಷ rigorous imprisonment. ಅದನ್ನು 1 year ಮಾಡಬೇಕಾದ್ರೆ imagine the quantum of fine that could be imposed. ಅಲ್ಲಿ ನನಗೆ ಬಿಟ್ರೆ ಆಗತ್ತೆ, ಅದು ಮೇಲೆ ಹೋಗುತ್ತೆ. Because the ಯಾರು ವೈಫ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ ಯಾರು? PW 5
And the son is
3 and 5. They are to be compensated. ಇಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 10 times. 10 times.
50 plus
4 and half. 90,000 ಆಗಲ್ಲ. ಇಲ್ಲಿ ಬಾರ್ಗೇನ್ ಏನಿಲ್ಲ. 10 times the fine amount. ಅದಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ let him undergo imprisonment. ತಗೊಳ್ಳಿ. ಅದೇ 5 lakhs. ವಿಲೇಜರ್ಸ್ ಅಫೆನ್ಸ್ ಮಾಡೋದಕ್ಕೆ ವಿಲೇಜರ್ಸ್ ಸಿಟಿಸನ್ಸ್ ಅಂತ ಏನಿಲ್ಲ. ಆಲ್ ಆರ್ ಅಕ್ಯೂಸ್ಡ್. ಅಲ್ಲಿ ಈಕ್ವಾಲಿಟಿ ಇದೆ ಎಲ್ಲರಿಗೂ. appellants being accused number 1 to 5. In AC 163 of 2012, on the file of the learned principal, Sessions Judge Kolar, are impugning the judgment of conviction and order of sentence dated 29th August 2013, convicting accused number 2 for the offence punishable under section 304 part 2 and sentencing him to undergo rigorous imprisonment for 5 years and to pay a fine of ₹50,000 with the default sentence, and convicting accused number 3 to 5 and 7 for the offence under section 324 of IPC and sentencing them to undergo simple imprisonment for a period of 1 year and to pay a fine of ₹10,000 each and with the default sentence. Appellants being accused number 2 to 5 and 7. Brief facts of the case are that brief facts of the case as made out by the prosecution is that, please be seated, sir, is that accused number 1 to 5, 7 to 9 formed unlawful assembly armed with deadly weapons, gone to the house of PW4 on 25/8/2012 about 11 p.m. with an intention to cause his death. When the deceased opened the door, it was accused number 2 who assaulted the deceased with a club on his head, causing fatal injuries, while accused number 3 to 5 and 7 assaulted PW2, 3, 6 and 7 with the deadly weapons and caused hurt. Thereby they have committed the offence. After investigation, charge sheet came to be filed. Trial court took cognizance of the offence for the offence under section 11 to 30, 143, 147, 148 LI there. The accused have and summoned the accused. The accused have appeared before the trial court and pleaded not guilty for the charges leveled against them. Prosecution examined PWs 1 to 16, hot-marked exhibit P1 to 21, identified him as 1 to 14 in support of his contention. Accused have denied all the incriminating materials available on record, but have not chosen to lead any evidence in support of their defense. Exhibit T1 to 5 were marked during cross-examination of PWs 1 and 3. The trial court, after taking into consideration the materials on record, came to the conclusion that prosecution is successful in proving the guilt of accused number 2 for the offence punishable under section 304 part 2 of IPC, while it has proved the guilt of accused number 3 to 5 and 7 for the offence punishable under section 324 of IPC, and accordingly passed the impugned judgment of conviction and order of sentence. Being aggrieved by the same, the appellants are before this court. Heard so and so much. There is the materials, point for consideration, partly in the affirmative, for the following reasons. As per the case made out by the prosecution,
The accused were having ill will against PW4 and they had the motive to cause his death. In that regard, they conspired together Accused number 1 to 9, armed with deadly weapons, went to the house of PW4 and after hearing the noise, the deceased, who was inside the house, came and opened the door. It was accused number 2 who assaulted him with a club on his head. He screamed out of pain. In the meantime, PW's one to 7 came rushing to the spot. 1 to 5 came rushing to the spot. In the meantime, PW 6 and 7, who are the neighbors, also came to the spot. The accused have assaulted. Accused number 3 to 5 and 7 have assaulted. PWs 2, 3, 6 and 7 and caused hurt. Next slide. Even though the prosecution contended that the accused have committed the offence punishable under section 144, 148, so and so, so and so. 307, 302 read with section 149 of IPC. The trial court rejected the claim of the prosecution in that regard, but formed an opinion that it was accused number 2 who committed the offence and punishable under section 304 part 2 and accused number 3 to 5 and 7 committed the offence for the punishable under section 324 of IPC. Admittedly, the prosecution has not challenged the impugned judgment of conviction and order of sentence. Next. It is the contention of the learned counsel for the appellant that there was no motive or intention to cause the death of the deceased by accused number 2. That was the reason why the trial court convicted accused number 2 for the offence under section 304 part 2 instead of section 302 of IPC. Next. The second contention raised by the learned counsel for the appellants is that there were no eyewitnesses to the incident to depose with precision that it was accused number 2 who assaulted the deceased. According to him, all the witnesses have deposed that they came to the spot on hearing the scream by the deceased, and by that time he had already collapsed. The act of assaulting the deceased was complete. But on going through the deposition of the eyewitnesses, including the injured eyewitnesses, they have stated that the incident had occurred just in front of the house of PW4. Immediately after opening the door of the house by the deceased, it was accused number 2 who assaulted with a club on his head. The post-mortem report supports the contention of the prosecution as the deceased had sustained injury over temporal ಅದನ್ನ PM report exhibit P12 ಇದೆ ಇಲ್ಲ ಸಾರಿ exhibit P7 ಇದೆ ಅದನ್ನ ನೋಡ್ಕೊಳ್ಳಿ ಒಂದು 3-4 ಏನೋ ಇಂಜುರಿ ಇದೆ. It is pertinent to note that the death of the deceased was due to cardiorespiratory failure as a result of massive hemorrhage, the massive dash hemorrhage due to head injury sustained. Head injury sustained. Therefore, it is clear that the deceased died due to head injury, due to failure of so and so massive dash hemorrhage due to head injury sustained, which is attributable to accused number 2. Even though the witnesses, the eyewitnesses, including the injured eyewitnesses, were cross-examined at length, the version of these witnesses remain unshaken. The evidence of the injured eyewitnesses is placed at a higher pedestal, and there are no reasons to disbelieve their version. The trial court has also accepted their version regarding causing of homicidal death not amounting to murder of the deceased, punishable under section 304 part 2 of IPC, and I do not find any reason to differ with the same. Next slide. It is the contention of the prosecution that accused number 3, 2, 5, and 7 have assaulted PW2, 3, 6, and 7 with chopper, club, and knife. The wound certificate pertaining to these witnesses are produced by the prosecution as per Exhibit P15 pertaining to PW3, according to which he had sustained 3 simple injuries. Exhibit P14 pertaining to PW2 according to which he has sustained 1 simple injury. Exhibit P5 is the wound certificate pertaining to PW6. As per this document, he had sustained 1 simple injury, while as per Exhibit P6 pertaining to PW7, he had sustained 1 grievous injury and 2 simple injury and 1 simple injury. The grievous injury referred to in Exhibit P6 is lacerated wound with swelling below right eye, measuring 3 by 1/2 centimeter, which was fresh in nature. The trial court, considering this description of the wound injury, came to the conclusion that it is in fact a simple injury and not a grievous injury as defined under the code. Looking to the evidence of the injured and the doctor in the light of Exhibit P6, Exhibit P6. I am of the opinion that the reasons assigned by the trial court are fair and reasonable, and the same could be accepted. Next, from the materials on record, it is clear that accused number 2 assaulted the deceased with a club and caused the head injury which resulted in his death, even though he had no intention to cause the death of the deceased. He had the knowledge of the consequences of his acts. Therefore, Section 304 Part 2 squarely applies to the offense committed by accused number 2. Next one. Accused number 3 to 5 and 7 have assaulted PWs 2, 3, 6 and 7 and sustained simple injuries. Therefore, it could be concluded that they have committed the offense punishable under Section 324 of IPC. I do not find any reason to interfere with the judgment of conviction passed by the trial court. Next one. When counsel for the appellant prayed for the showing leniency in favor of the appellants, contending that there was no motive for the accused to assault either the deceased or PWs 2, 3, 6 and 7. The incident must have occurred in heat of passion. It is also contended that the incident is of the year 2012 and 13 years have elapsed from the date of offense. When counsel for the appellants further contended that accused number 1 was in judicial custody for a period of little more than 1 year, while accused number 3 to 5 and 7 were in custody for a period of 18 days. Therefore, he prays for giving set off to the imprisonment they have already undergone. However, learned HCP seriously opposed submission, contending that deceased had lost his life and it is really a loss to PW, who is the wife and son, PW 3 and 5. 3 is the wife and son, PW 3 the son and the wife, PW 5 the wife of the deceased. They are not being compensated for the acts of accused number 2. And the other injured eyewitnesses have sustained injuries and therefore they are not entitled for any leniency. Next paragraph. Considering the facts and circumstances of the case, that the accused were never intended to cause the death of the deceased, but they have gone to the house of PW4 for the purpose of causing his death. Fortunately, he escaped. He could escape while the deceased received the fatal injury. The appellants or the rustic villagers, keeping them in custody to serve the remaining sentence will not endure to the benefit of the family of the deceased. Next. As per Section 304 Part 2 of IPC, the offence is punishable with imprisonment of either description for a term which may extend to 10 years or with fine or with both. Instead of imposing substantive sentence on accused number 2, the offense under 304.2 of IPC, I am of the opinion that the set-off could be given to him as he has already undergone imprisonment for more than 1 year, and enhance the fine amount imposed by the trial court to rupees 3 lakh, 2 lakh 50,000, 2 lakh 50,000, out of which a sum of rupees 2 lakh could be paid to PW3 and 5 as compensation. Next part. Accused number 3 to 5 and 7 are sentenced to undergo simple imprisonment for 1 year and to pay fine of rupees 1,000 each with the default sentence. It is stated that they were in custody for about 18 days. Considering the nature of injury, that all of them have sustained only simple injuries, I am of the opinion that while confirming the sentence, or while confirming the conviction for the offence punishable under section 324, they may be given set off for the sentence, for the imprisonment which they have already undergone, with the fine of rupees 10,000 each. 10,000 each with the default sentence. In view of the above, I proceed to pass the following. Appeal is allowed in part. ಅದು answered in partly in the committee. The judgment of conviction dated so and so, passed in so and so, by so and so against the appellants is confirmed. The order of sentence passed by the trial court is modified as under. Accused number 2 is sentenced to undergo simple imprisonment, undergo simple imprisonment for 1 year with fine of rupees 2.5 lakhs with the default sentence, in default, to undergo simple imprisonment for a period of 6 months. Accused number 3 to 5 and 7 are sentenced to undergo simple imprisonment for 15 days and to pay fine of rupees 10,000 each. In default, to pay fine to undergo simple imprisonment for 1 month each. On deposit of the fine amount by the accused, a sum of rupees 2,50,000 is ordered to be paid to PWs. PW5, the wife of the deceased, and in her absence to PW3, the son of the deceased, as compensation. As provided under section 357 of CRPC. Send back trial court records. Judgment of conviction confirmed. Order of sentence modified. Accused number 2 is sentenced to undergo 1 year simple imprisonment. He is given set off. He is liable to pay fine of rupees 2,50,000. And the accused number 3 to 5 and 7, they are given set off 15 days imprisonment. They were given set off. They are liable to pay fine of rupees 10,000 each. And out of the fine amount, rupees 2,50,000 is to be paid to PW5, the wife. Whether she is alive, ಗೊತ್ತಿಲ್ಲ. If not alive, to PW3 on due identification. On due identification. The accused shall deposit fine amount within ಅದನ್ನ ಕೊಡದೇ ಇದ್ರೆ ವಾಪಸ್ ಮತ್ತೆ ಅದೇ ರಿಸ್ಟೋರ್ ಆಗುತ್ತೆ within 4 weeks from today. Send back trial court records. Yes.
Serial number 30, Girish Mke.
ಯಾವುದು?
Serial number 30.
ಎಸ್ ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? ನಾಳೆಗೆ ಹಾಕಿದ್ದು ಇವತ್ತು ಟೈಮ್ ಆಯ್ತು.
Serial number 35, Ramesh Ichi.
Tomorrow. Reference ಇದೆ ಇವಾಗ ಅಲ್ಲಿ. ನೀವು ಕರೆದಾಗ ಇರೋದಿಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರೆ ಅದನ್ನೇ ತಗೊಳ್ತಿದ್ನಲ್ಲ ನಾನು. Absent. It was passed over. ಮುಗಿಸ್
Second is serial number 8. It seems that yesterday while reading that it seems that the complainant was not made as party.
I will safeguard the interest of the complainant.
They are ready with the matter.
Yes. Give the issue notice to amendment to
No, we are ready.
Yes.
Tomorrow. Can I say it again?
Repeat it.
Let's first
ಬೇಡ ಕಸ್ಟಡಿನಲ್ಲಿ ಇದ್ದಾರೆ.
ಅದಕ್ಕೆ ಫಸ್ಟ್ ಇಸ್
ನೋಡೋಣ. ಯಾರು ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ I will take your matter.
Because 22nd March is accused sister's marriage. That is why there was some concern.
Yeah, ಯಾವ year?
21 March is in jail since 5 years. As of today, it's 5 years. 7 years of custody period. Will also take.
Yes, sir.